In just a minute, our colleague and co-chair Representative Kuhn is just presenting something in criminal justice. So she'll be here in a moment. And I know the folks who are stakeholders in LD 1444 are just wrapping up some discussions. So we can just be at ease for another couple minutes and but don't wander far. Yes. Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. We are awaiting Representative Kuhn, but she, I'm sure, will be here in just a minute. And so we'll get started with committee member introductions. And let's see, Representative Sinclair, would you like to start us off this morning?
Good morning, and thank you for being here. My name is David Sinclair. I'm here for the people of House District 50, which is the city of Bath.
Good morning, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Good morning, everyone. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Milton, Hanover, Roxbury, and my hometown of Rumford.
Good morning. My name is Danny O'Halloran, and I represent House District 20, which is the majority of the industrial city of Brewer.
Good morning, massive gallery. I am Senator David Hagan, Senate District 10. Could get that one out with a straight face. 12 towns surrounding Bangor. And
Good morning, I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
Good morning, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Good morning, everyone. My name is Ellie Sato. I represent House District 109 in the beautiful city of Gorham.
Good morning. I'm Mark Babin. I represent House District 3, Northeast Aroostook County. I was going to name them all.
Good morning and welcome, everyone. I'm Elizabeth Caruso. I represent the people of House District 72, which is much of northern Somerset County.
I'm Ann Carney. I represent Senate District 29. That includes South Portland, Cape Elizabeth, and some of Scarborough. I serve as the Senate Chair of the committee, and I'll be doing the work session for LD 1444. Before we begin, though, I know that we have a special guest who's been doing a job shadowing, and I will turn the floor over to Senator Hagan.
thank you very much. I have a former student. I was a teacher for a long time, history teacher in Hamden. And Samantha Houghton, right there, if you wouldn't mind, just go ahead and stand up, is one of the more remarkable students that I had in my 37 years. I had her in middle school, of course. I'm a history guy. She's just fantastic. She goes to the magnet school in Limestone and plans to attend MIT. She's a sophomore right now, and she's studying our bill. So it's really great to recognize Samantha.
Thank you.
Samantha, welcome to the legislature and to the Judiciary Committee. So Eli, could you please, we're joined today by Eli Murphy, who is the OPLA Legislative Analyst, and also Susan Panett, our committee clerk. And Eli, can you just orient us to where we are on this bill that was recalled?
Sure. Eli Murphy, Office of Policy and Legal Analysis. Somewhere in your folders, you should have the blue bill analysis that is dated May 9th, 2025 for LD 1444, an act to prevent foreclosures without strict compliance and notice or with notice requirements. This bill had a work session last session in which the committee voted and amended it. You should also have in your files a pink amendment from the language review. The majority of this committee passed an amendment that was then reported out to the floor, at which point, before any substantive votes on this bill happened on the floor, it was recalled to committee for further changes or discussions. You will remember from yesterday with the indemnification bill that when a bill is recalled back to committee, all amendments are removed from it. So you do have the language that was discussed. However, this bill is back in the original posture of the printed bill, which you also should presumably have in your folders as well. And so while the discussions and work on this bill have continued since that time, from a procedural standpoint, there's no official amendment that is being worked from yet, while you do have that text in front of you. This bill, content-wise, to kind of reorient you, there was a long-standing court case holding called Pushard, which addressed when there was a mistake in a foreclosure document, or not, yes, a foreclosure document, and it really created what was kind of known as a system where if there was any sort of typographical error in that document, it completely invalidated that foreclosure process. That was the case for a long time. Eventually in, I forget the date of Finch, but in the early 2020s, I don't have the case in front of me, I apologize. In the early 2020s, the law court decided Finch, which completely swung the pendulum the other way, and made it much more difficult and kind of, or I shouldn't say difficult, but we're talking about two extreme ends of that case. And so Pushard was in vast favor of the homeowners, Finch was in vast favor of the lenders, and then this bill sought to kind of find that middle ground, and that's where that amendment that we discussed last session kind of took that, trying to cut that middle ground there. That is at which point this committee reported out. Beyond that, there have been some conversations, but at that point, I think I'll turn it over to Senator Carney of what is currently going on with this bill.
Thank you very much, Eli. And so committee members, at the toward the end of the last session, we thought that we had reached an agreement that would resolve a whole bunch of outstanding issues regarding both Finch, the application of Finch, and also then the retroactivity. And it turned out that what we thought was an agreement was actually not an agreement. And that's why we recalled the bill and we to committee and have been thinking about how we could make progress on any of these issues. And so what I'm would like us all to consider today is a very simple compromise on at least one of the issues. And that is the issue of whether Finch, the Finch decision, which reversed, as Eli said, this long-standing interpretation of the law, which greatly favored homeowners. Finch swung it the other way, but there's all these cases kind of in the middle that were where judgments were entered in favor of homeowners prior to the Finch decision. And so the question is Finch retroactive? Could it be applied retroactive to those settled cases? And so what I'm suggesting we consider today is just resolving that one issue of retroactivity by adopting essentially what would be unallocated language that would simply say that the holding of the Finch case cannot be applied retroactively to foreclosure actions in which there was a judgment entered prior to Finch. And so what that does is it would protect decisions that people have made regarding real estate when Finch was not anticipated to be the law, prevent all of those decisions from being upended now that Finch is the law court's interpretation of the statute. So it's not changing the statute, it's just dealing with that one piece, which is saying that that Finch should not be applied retroactively. I am not an expert in this. I would ask first, perhaps Frank D'Alessandro from Maine Equal Justice to come up and explain the benefits of this. And then I know that we have a representative here from the Maine Credit Union League, my former colleague, Dan Cummings, who also would explain it. And I believe that this is a partial solution that everybody can get behind. Before we move on to that, I'd love to give Representative Kuhn a moment to introduce herself.
Thank you. Good morning, everyone. I'm Amy Kuhn. I represent House District 111, which is most of the town of Falmouth, and I serve as the House Chair of the committee.
Frank D'Alessandro, could you please come up and speak briefly to this resolution?
One of the concerns after the Finch decision was entered in January of 2024 was whether or not what would happen to all these other cases that had been decided under the old law, and what would happen to people's, title to their property. And so one of the things that this proposal would do would take away that problem. And so that the cases that were decided under the law that was in effect prior to the law court's decision in Finch would not be impacted. And those people who relied upon those decisions in making decisions would not be harmed.
Thank you. The document that Supi is passing out to everyone this is the amendment that we had been working on at the close of the prior session, which is now, because it's been recalled to committee, this amendment is no longer part of the bill. So thank you. Let's just see if there are any questions either for Eli or for Frank D'Alessandro regarding this. Yes, Representative Lee.
I guess my question is that happening right now? Or are there attempts to retroactively apply Finch to cases that have already been decided?
Yes, as a matter of fact, right now, there's a case in front of the First Circuit on this issue.
Again, not an expert in this area of the law. Why is that not res judicata? Like, why is that not an already decided decision?
Well, the argument, what's being argued is that it's not. I believe that it is. I believe that it is res judicata,
Yeah.
but that issue is not clear enough so that it's not. So now it is being litigated.
Okay. And then my second question is
Just to clarify, there was a case in the United States District Court for the District of Maine where there was a ruling that, I believe the ruling was Finch could not be applied retroactively.
That's right.
And then that was appealed to the First Circuit Court of Appeals.
so the posture is presently that it would be res judicata.
Yes, but we don't know what the
Okay.
First Circuit would say.
My question for Eli is how would we do this via unallocated language? And is that something we've done with prior decisions?
Yep. I can't off the top of my head speak to if it's something we've done with prior decisions. If you look at that amended language, really what this amendment would look like, that pink, if you either had your copy or the copy Supi gave you, if you look down on section 3, retroactive application, the holding of, in the The holding in the case of Finch v. US Bank NA 2004 ME2 may not be applied retroactively. And then there's other language that relates to the statutory change that would be taken out. Because it would be a standalone resolve, there'd be a bit extra kind of formal language, resolve, that, etc. But essentially it would be that language. It is a law of Maine. It just does not go out into the statute books. It's similar to like, you know, a declaration by the legislature saying as such. Usually these are used in like directing an agency to do something. You know, it doesn't go into the statute books, but you're saying the law is that you do this. So this would be directing, I guess it's directing, you know, the courts that this is how this should be applied.
So,
Yes.
I'm trying to think of how, given that there's that First Circuit appeal presently happening, what the effect of us doing this now in the middle of that appeal would have, if any.
I think part of that would come down to a timing thing. You know, this certainly wouldn't be law until 30 days or 90 days after adjournment. As we are very familiar, the First Circuit doesn't operate on any sort of schedule. And so they could decide it beforehand, they could decide it after. It's one of those things of, you know, is this law before they decided? So I'm not sure.
Any other questions for Frank D'Alessandro? And then we'll call up Dan Cummings on behalf of the Credit Union League. Yes, Representative Caruso, go ahead.
Thank you. I had the same question. I thought, why wouldn't we wait until the court decided? But also before that, this is kind of like general and arbitrary to me. Can you explain the case that, explain an example of something that you think this would apply to in terms of retroactivity, or the one that's in the courts right now?
So in the case, I was involved in the litigation that's going up to the First Circuit. Okay, the bank was arguing that as a result of the Finch decision that they would be able to pursue, reopen the case despite the decisions that existed prior to Finch, because of the Finch decision, and that gave the banks the power to institute a new foreclosure action.
I'm sorry, I wasn't clear in my question. What was the case in question in terms of why should the bank be giving away the house to the homeowner?
The Pouchard decision that was issued.
Nope, no.
So prior to the Finch decision, the law in the state of Maine was that the bank had to prove certain elements in order to be entitled to a foreclosure. And what the law court held in the Pouchard case, which was the case that was before Finch, was that what they said was that in any case that you bring as a plaintiff, so the bank would be the plaintiff in a foreclosure case. So in any case that you bring as a plaintiff, if you can't prove the elements, you lose, and that you can't bring a new case, and that there shouldn't be a special rule for foreclosure cases that deviates from that general rule.
Thank you. It's not.
I think it'd be helpful to hear from Dan Cummings on behalf of the credit unions, because this is something that both people representing the landowners who are involved in foreclosures and the financial institutions agree to. So Frank, thank you for answering our questions.
Good morning, Senator.
Good morning. Could you introduce
Committee
yourself,
members?
please?
Excuse me?
Could you please introduce yourself?
Yes, my name is Daniel Cummings. Excuse me. I'm an attorney in Norman, Hanson, and Detroit, and I represent the Maine Credit Union League. To address the senator's question, I first want to just kind of give I guess, a quick background, so to speak, of where the league views the issue and how we come about it. And that is, we have a disagreement, I think, with the characterization that Pouchard and its progeny is necessarily a long-standing, legal doctrine that is suddenly, flipped by Finch. I think Pouchard was in 2017. I think there were some prior cases that, in my view, kind of started the ball rolling really in roughly 2009 to 2010, when there was some legislation that you folks passed regarding mandatory mediation and trying to address some issues. But if you look at property law and law of mortgages and how those are dealt with, property law is long and old, and the principles around, if you're in the legal field, you can be citing to court cases from the 1800s that have still principles that apply. So in our view, it was really in 2009 and that kind of decade that started coming that really Pouchard and the other cases actually flipped what had really been the view of mortgages, and that the more recent cases have gotten, I think, things back closer to where they were. Now, that's not to say that there aren't concerns, and we understand that, the league understands that, with regard to some activity and practices by mortgagees and that need to be addressed. And I know the legislature has done that. Again, I'll just quickly put this in so it's in the back of your mind. Title 14, Section 6113 deals with the mortgagor servicer duty of good faith. So there are remedies that you folks have in place. So I'll quit my speech there and stop with the particular issue of the retroactivity that we're talking about, the Finch not applying retroactively. The league doesn't have any concerns, with that being included. It's not necessarily saying it would advocate for it, but it's not going to take any position against it either. And I'm not sure that that any court, I know there's been some discussion about res judicata. I think those principles, would apply in the cases. I think Frank mentioned that as well. So it'd be interesting to see how the First Circuit comes down on that. But
Thank you. Are there questions for Dan Cummings? Yes, Representative Lee.
Is the case we're talking about, and sort of doing some searching, is it this Fuller v. WVMF funding case?
Yes.
Thank you.
Any other questions for Attorney Dan Cummings? How about we take a little, I'll recognize Representative Henderson, and I was going to suggest that we take a little caucus and let this digest for folks for a couple minutes. Go ahead.
Thank you, Madam Chair, and thank you, Attorney Cummings. Your kind of the landscape of things has been helping, and transparently for you and the committee, it's been a while since we've talked about this. So my hope was that many more questions would be asked so that I could kind of remember the landscape in and of itself. But because that hasn't happened, I'm now forced to transparently tell you I need a little help getting on the same train as everybody else. So the Pouchard case in 2017, forgive, I'm not an attorney. So it essentially said that if the bank, if their filings was in error in any way, that they didn't reach the quote unquote elements of foreclosure, that the lender or that the person who had the loan would not be held responsible for that loan. And people have referred to it as the homeowner getting a free house. Am I understanding that accurately?
yes.
Okay. And then the Finch case, can I guess ask you to just briefly explain to us how the Finch case overturned that or pulled that back a little bit, so that I can understand exactly what with the retroactivity piece that we're talking about.
Right. So in Finch, the court basically, took a look at the Pouchard case and analyzed this area of the law, both in terms of Pouchard and prior, and said, no, that we were wrong on that. The effect isn't res judicata. It's basic, that prohibits a mortgagee from filing a subsequent foreclosure action, and doesn't prohibit the mortgagee from enforcing the promissory note. Because under the law, you've got two types of enforcement that Maine law is seen as actually distinct, even though they're tied together. And that's personal liability in connection with the promissory note that gets signed, and then basically they call in rem or property enforcement as it relates to the mortgage. And those historically have always been viewed distinctly. So even if you pursued one and not the other, it didn't bar a later subsequent action. Res judicata principles didn't apply to say, well, you already sued on the note and you didn't bother to sue on the mortgage, so your mortgage gone. And that never happened before. And so effective Pouchard essentially blended these things together and said, okay, you take a runner at it and you miss because your 6111 notice was erroneous, then hey, you tried, you missed, and now you can never bring another foreclosure action again on the mortgage. And by the way, you can't even bring one for personal liability on the promissory note. So the Finch case basically said, no, let's go back to where we were and properly apply principles of res judicata. And one of the things, and it was tied to 6111, and that's why I think there's some language in the proposal to deal with the acceleration issue, is that 6111 said, look, a mortgagee, you can't accelerate a mortgage until you send this proper notice. So what happened was, if the notice was improper, then instead of the ruling being your acceleration didn't occur, and therefore there's no res judicata to bar you from bringing it again, court decisions prior to Pouchard said, no, bringing the action effectively accelerated it, even though the statute said you can't accelerate it unless you have a proper notice. Well, no, you didn't have a proper notice, but the filing of the complaint accelerated. So anyway, it's all these principles where Finch just said, let's go back to where we were. If you made a mistake on it, you'll have an opportunity to bring it again, but there'll be certain consequences as to what is subject to res judicata. You won't be able to collect certain things that you attempted, in your failed effort, which there was a case in the end of November in the law court that actually applied that principle where, it prohibited collection of, all of those amounts that had been subject to the first failed foreclosure. So any of those amounts, attorney's fees, those kinds of things, mortgagee, you can't tack it on. Res judicata or issue preclusion knocks those out. But otherwise, if it's a new default going forward, you still have your rights with regard to your note and your mortgage. So it's probably a long-winded way of going about it, but so it basically makes clear that res judicata doesn't prevent a future sort of second foreclosure.
Yes, Representative O'Halloran.
I have a couple, I'm trying to understand this as well, but I know that foreclosures have happened in this country not too long ago on people who weren't even behind in their mortgages because of screw ups and electronic stuff with these big banks. And I personally feel like credit unions do a great job, but I'm concerned about, you had mentioned like fees that you can collect and stuff like that. And I'm not sure if this bill addresses this or if Finch addressed this, but some of those fees have been so egregious over the years from these big lending institutions, hard money lending institutions, that even if a person could catch up on it, there's no way they could pay all those crazy fees. And sometimes it seems like they do that more on a home that they know is going to be more lucrative on their end. But is there anything in there that protects people for that? Because I know in Maine where, a lot of us are self-employed, you get hurt, you're out of work for 3 weeks. That's really all it will take to lose your home.
is there anything in,
That
Sorry.
will, that limits the, like the egregious amounts of fees that these banks are charging. I mean, they come up with all kinds of uh,
any,
names for all
Right.
these fees that you're.
I mean, any limits would be, contained in both sort of the contracts at play. There would have to be something in the promissory note and or mortgage that would allow certain charges. And then whatever the various, consumer protection laws in place that prohibit certain kinds of practices would be, where the limits would come in with regard to, what can get charged and under what circumstances. So they wouldn't come in the context of the foreclosure necessarily, although if they're violating, not following, the contract or applicable, consumer protection laws, it can get flushed out in the context of a foreclosure, where it gets pointed to the judge to say, these are unenforced, these aren't part of the deal.
Right. Unfortunately, most people don't read those, and the title companies I go to don't explain that.
Right.
And a lot of people right now are saying, like, even after their first mortgage payment, they're starting to get missed mortgage payment. They're starting to get notice that they're filing for foreclosure. I mean, that just is so much faster now than it used to be.
I'm not sure on that. I know there are, I think there's some federal protections with regard to being able to actually commence a foreclosure. I think I don't have it before me, but I think it's like have to be at least 120 days,
Yeah, that's.
in arrears, before it can be commenced.
Yeah.
And then obviously, there's right to cure, provisions where notices have to go out and give a homeowner, notice and warning and detail. That's what your section 6111 and Title 14 does, is to say itemize, what's owed, so that there's nothing that should be hidden at all. It's
Yeah.
supposed to
No,
be spelled out in your right to cure 6111 notice.
thank you.
And so just as a refresher, and I'll recognize you in a minute. So what I'm suggesting to the committee is that we take up a whole new amendment to this legislation to LD 1444. And that amendment would be change the legislation into a resolve. And the resolve would simply say that it would have some other prefatory language that Eli will fill in his role as analyst, but it would basically say the holding in the case of Finch v. US Bank may not be applied retroactively. And so it's just settling one piece of, I know we're hearing a lot of different sides and we probably feel differently about the underlying issues, but we're just addressing this one little piece of that bigger dispute about whether Bouchard is right or Finch is right. We're just dealing with the retroactivity because it's so disruptive to upend things that were decided when everybody involved thought the case law was settled, and then a subsequent court decision changes that case law. So that's the issue that we're just focusing on right now. Representative Caruso, I know that you had your hand up. Go ahead.
Thank you. Two questions, a question for you, or maybe Eli. So if Bouchard happened in 2017, what year did Finch happen?
2024.
So we're talking about those 7 years. So to be clear, sir, you're saying that it is your opinion, the credit union league, that you would be okay with this retroactive provision? That what you
Yes.
provided?
Let's see, let's clarify, because I think Representative O'Halloran, I think that what I understand is that the credit unions are in agreement with this language.
Yeah, I thought she said.
It's my understanding.
I'm just gonna, let's take it from the top. Why don't you re-ask your question, Representative Caruso, and then Dan Cummings, if you could re-answer it. Thank you.
So it's my understanding that what is being proposed is that Section 3, the retroactive application, that that you would be, that the league is not against having through Senator Carney's proposal for retroactivity for that 7-year period, if the cases that are being, or the situations that happen within those 7 years. That way.
Correct, yeah, the league essentially is neutral on that application, so we don't, the league doesn't object to it, but we're not necessarily advocating for it either. So
Right,
it's
okay.
Neutral. but
You're neither for
not-
nor against.
Right.
In this case, if there was, I have another question. Is that okay?
You may go ahead.
Is it your understanding that if there was a situation where, for example, an attorney made a mistake in the provision of what they gave to the homeowner and they made a typing error, that the banks would suffer for that, and if this were to go into effect?
Well, I think the effect of Pouchard was that they would suffer from it. I think the effect of Finch
Right.
was to soften it. So I think where we stand now with Finch applying, then the consequence, there's consequence to, errors being made, but it won't be, from our view, as draconian to prevent, future enforcement.
Very good. Thank you.
Yes, Representative Lee?
If ever there was a practical demonstration of why stare decisis is important and courts should be incredibly careful when overturning their decisions, I think it's this. Is it fair to say that there are no members of the credit union league or main banks that are attempting to enforce retroactively Finch to any final judgments that exist presently?
As to main credit unions, I'm not aware of any that are in that situation.
I'm reading the decision in Fuller, and I feel like it's a fairly preposterous argument made by a Delaware bank right now.
Yeah, it would surprise me if they prevailed in that, but because at that time, Pouchard, controlled. And you're right, your point's well taken on stare decisis. I think issues where did the stare decisis start to flip?
I would like to see if Josh Stearman from the Maine Bankers Association wished to also answer your question, because Dan Cummings can answer on behalf of the Credit Union League. Welcome.
Thank you. Josh Stearman, representing the Maine Bankers Association. Could you please repeat the question?
Yeah. Are there any banks that you're aware of besides this Delaware bank who are attempting to enforce Finch retroactively to current final judgments that were decided under Pouchard?
I'm not aware of any banks in Maine pursuing that, but I can't speak definitively for every institution.
Is your organization opposed to Senator Carney's proposed amendment?
We're not prepared to take a position on a nuanced legal issue that we're just having put in front of us today. I appreciate the direction this is going. Certainly, I think it feels in the right direction, but to have a legislative interference in pending judicial matters, I have a lot of caution to wade into that. So I'm not disposed to make a statement on that.
Are there any other questions for Josh Stearman? Representative Henderson? No. Okay. Any other questions for Josh Stearman?
Thank you.
I have a question for you. If we, would you be able to have this proposal reviewed and get back to us before January 30th,
Certainly.
which is our deadline for acting on this
Certainly.
legislation. Thank you. Any other questions? Not seeing any.
Thank you.
Thank you. And your question for me?
Yes, thank you, Madam Chair. So just before we go off to caucus, to understand your proposal would be striking section 1 or section 2 pardon me. So the only thing that the bill would be a resolve talking about the retroactivity as outlined in section 3, correct?
Correct. And it would only be part of section 3.
Okay,
It would just be the first phrase prior to exception. So just the holding may not be applied retroactively.
okay. So that answers my second question. Thank you.
Okay, and I think that my answer is going to be amended a little bit by Eli. Eli?
Just for a full picture, it would look something like, I mentioned there might be some different prefatory language that sets up with any resolve. And so it would have a new title that was something along the lines of like resolve, clarifying the retroactive application of Finch v. US Bank, NA, to et cetera. And then the only bit of text there would be resolve that the holding in the case of Finch v. US Bank, NA 2004 ME2 may not be applied retroactively, full stop.
Representative?
What kind of legal weight does a resolve hold in courts?
It is it is an act of law. It is.
Okay.
Yes.
Thank you.
I'm just going to suggest, committee members, that we have a little caucus break. I know that today we have a lot on our agenda, so let's take a break for about 10 minutes and come back a few minutes after 11, please. And if we need additional time, we'll sort it out then. So we'll be at ease for about 10 minutes. Committee members, we're going to get started again. Thank you, everyone, for returning from caucuses so promptly. We're going to continue the work session on LD 1444. And before we move on to a motion, does any committee member have any question for anyone? If they wish to hear any additional information? Seeing none, I would recognize Representative Kuhn to make a motion.
Thank you. I would move ought to pass as amended. Creating a resolve to simply state that the holding in the case of Finch versus US Bank may not be applied retroactively.
Is there a second, seconded by Representative Sato? Is there a discussion of the motion, committee members? Yes, Representative Henderson?
Thank you, Madam Chair. And thank you for bringing forth this amendment. I will say that where with any resolve, I'm assuming that there's going to be like a lot of preliminary statements, right? Like whereas. So given that, I don't feel comfortable voting today on language I haven't seen yet. I also know that we're waiting to hear back on an opinion from the Bankers Association, who said that they could get us, an answer here before too long. We do have some time. So I think my opinion is that today we should table this, readdress it, get their answers, see some language from Eli, so we can understand exactly the language that we're voting on for the entire resolve, rather than moving forward with a vote today.
Well, I think we have one motion on the table. I would just, so wanted to make a motion to table.
I mean, I guess maybe discussion, but I'm prepared to make a motion when the time is right.
I would love to reply to that because, so we're changing something that is a statutory document to a resolve, and that will involve work by Eli and by the revisor's office. It will take some time to get that finalized. I appreciate that some people may not want to vote in favor today. And what I guess my promise to the committee is that if you vote in favor and then you don't like the language, I will move to reconsider. If you vote no and you end up agreeing with the language and we get a positive response from the Maine Bankers Association, then I would also move to reconsider. But my strong preference is to get this mechanically moving forward, because we do have just 2 weeks until we're supposed to have voted everything out. And so that's my two thoughts. I'm going to recognize Eli first.
And
I know
one
others want to
point
weigh
of
in.
clarity for Representative Henderson, when you're discussing the preliminary language, that would not be included for resolve. That kind of preamble would be for if there was an emergency preamble. It resolves similar to a bill would simply have the title and then whatever the unallocated language is. And so if you want that full language, I've written it out based on what we were just discussing. It's simply, a new sentence or a new title that's about a sentence, and then the resolve text, which is about a sentence, which is about half of what that section 3 in that amendment is. That would be the entire content of what this amendment would be, unless the committee added a emergency preamble, which would then add more things.
Representative Henderson?
So it's an emergency preamble on a resolve that would include whereas, but this resolve in and of itself isn't going to have any of that preliminary language.
Unless the committee votes to include that, correct?
And that's not part of the current pending motion.
To my understanding, no.
Okay.
And so Eli, can you just take us from the top and tell us what the document more or less would look like when it
Sure.
comes back on language review?
When it comes back on language review, it will look very similar to the document that you have, the pink one in front of you. So there wouldn't be a new preamble or anything, but it would say committee amendments to this. And it would first say strike the title and replace it with the working title that I scribbled out here is resolve, clarifying the retroactive application of Finch v. US Bank NA. And then it would have another line that says strike the entirety of the text and replace it with the following. And then what I wrote out is resolved that the holding in the case of Finch v. US Bank NA may not be applied retroactively.
Would anyone like that repeated? additional questions for Eli? Senator Hagan and then Representative Poirier? Okay, Representative Poirier?
So Madam Chair, you had given the Bankers Association, you had asked them if they could prepare that answer by the end of the month, and I think that we should allow that. That would weigh into my decision, whether or not I would support this resolve or not. So I would be much more comfortable having that motion to table. And that they can still get the language ready in that meantime. And but once we hear from Bankers Association as far as the opinion.
Senator Hagan?
I like the new amendment. I would like to vote for it. But until the information comes, which is coming, I will vote no. And that would certainly sadden my heart because I don't want to vote no, but I will. And I think patiently waiting, we're going to have to wait anyway. So so for me, tabling makes sense. I don't want to vote no, but I will today. And it seems odd to me that we're going to wait. Why would we pass a bill and just do a reconsider when we can just table and then do it correctly then? That would be my 2 cents.
I'd like to reply to that. I appreciate where you're coming from because Maine bankers had supported the original legislation with the amendment. And this is a much more modest change than the original legislation with the amendment would have been. Was assuming that they would agree to it, and I know that they haven't, and they're going to come back to us with an opinion. And so I do think it makes more sense now to have Eli write a draft, and then we will reconsider, we will take it up, we'll table it today, and then we can take it up when we hear back from the Maine Bankers Association. So is that, I'm just going to ask my co-chair what she thinks of that. Put you on the spot.
I think that's a good plan.
Okay. I wouldn't. So I'm going to recognize Representative Henderson for the purpose of making a motion to table.
I move that we table this item.
Seconded by Representative Poirier. All those in favor? And that is unanimous among those present. And so Eli, do you need any further information from us? Okay, thank you. All right, thank you all. And especially thanks to all who came today to the committee to assist us with our work on this legislation. So the work session on LD 1444 is over. And we're going to change gears for a moment and take up our next bill in just a couple minutes. Committee members, we're going to take up our next bill at 11:25. So if people need a 5-minute break, you may take it now. Welcome, everyone. We are going to open up our next work session. This is the work session on LD 1821, an act to ensure responsible business practices by licensed firearm dealers. It's presented by our colleague, Representative Kuhn. And Eli, I think I'm just going to turn it over to you to orient us to where we are in this bill.
Sure. This bill had a public hearing and work session last session. It was then carried over for additional work that was going to be done by the sponsor, which has been done and should be passed out. I did send out an amendment to you sometime earlier this week. There is another amendment that SUPI is passing out now that makes some slight changes to that amendment. In addition to that, and certainly those changes either I or Representative Kuhn can go over. In addition to that, SUPI also will be passing out a chart that was prepared by Representative Kuhn comparing this amendment to, or either this amendment or the bill to both Maine law and federal law, as well as recommendations by ATF. And so we can, I guess, start with whatever part you want to start with, though SUPI is still passing out some materials.
Okay. Yes, Representative Kuhn.
Thank you. I was hoping just to provide a little bit of overview to ground us in what we're talking about today, and then walk folks through this new amended version of the bill. So just to get everybody back in gear, this is a bill that was carried over from last session. The reason we're taking up this bill is to try to establish a forward-looking framework that helps to prevent theft and improve public safety from firearms dealers. A lot of states have similar laws in place: Maryland, Connecticut, Minnesota, New Jersey, New York, Massachusetts, Illinois, Colorado, lots of states, in order to try to prevent stolen firearms from getting into trade. Lots of different kinds of businesses in Maine have to protect their inventory or protect their premises to benefit the public. For example, if you run a pharmacy, you need to lock up certain controlled substances at night so they don't get stolen. If you run a bank, you have to lock up cash because that's something that can be stolen. If you run a restaurant, you're subject to certain requirements to make sure that the food you produce is safe for the public. And so this is very much along those same lines. It's not intended to be a gotcha situation in any way. It's intended to set up a framework that assures safety. So let me walk you through the bill that we have in front of us. I did make a couple of changes just yesterday following a conversation with some law enforcement folks to try to just bring you the best possible version we can. So I'll walk you through that. On the first page, we've removed Office of Violence Prevention.
Can I interrupt you for a minute?
Yes.
I just, because it's been a long time since we saw the original bill, can you just go through not just the
Yes.
changes, but the whole thing?
Yes,
Thank you.
absolutely. All right, so we start with the definition section.
Hold on a second.
I'm going to interrupt just for
Yeah.
a brief second. So there's been a couple of yellow amendments. The one that we are working from is the one that says 1/14/26 in the top right corner. The other amendment does not have a date on it.
Thank you for that. All right, so we begin with the definition section, and you'll see one of the definitions has been removed because it's not mentioned elsewhere in the bill anymore. Next, we go to security. This is really at the heart of the theft prevention. In the prior version of the bill, it called for rulemaking on the part of the Department of Public Safety to identify certain security measures that a business would have to undertake. And it did not provide a lot of clarity in the bill itself. As we heard in the work session, that was problematic for dealers because they didn't know what to expect. And it was problematic for the department because they felt they didn't have resources to do that kind of rulemaking. And so what I've tried to do is establish a standard that exists in other state laws that we can just insert here. So what it does is it requires the dealer to use reasonable measures to secure either the premises or the inventory. This is a reasonableness standard, much like we see in a lot of different kinds of bills, and is very similar to what's in existing law. In particular, Maryland uses the terms reasonable measures or reasonable controls. So that's going to vary depending on your particular business and the volume of your inventory, but that's an established standard to do that. And is not hopefully overburdensome. We've gotten rid of all specific examples around required alarm systems, video surveillance, and so on. All right, then we get to employee vetting and training. Obviously, the folks who work in the store have a big impact on the safety of the public coming and going and on the safety with respect to the inventory. So it does impose some standards, some of which exist in federal law related to training. So the first is requires that people who work in transactions involving firearms be 18 years old, and also that they themselves have passed a background check. In the prior bill called for prospective employees and employees to be run through the NICS system, which it turns out they're not allowed to do. So we changed that to require the same kind of system where if you're going to go volunteer in the schools, for example, or work in the schools, you go through their private company. It's about a $50 fee, and that's how you get demonstrated eligibility for that. And so that adopts this kind of system instead of the NICS system, which was not really implementable, as it turns out. Then we get to training for employees. The previous version called for DPS to develop training materials. We heard pretty clearly that's not something that they really are in the business of doing. And I came to learn that there's a tremendous amount of existing material that's really strong. There's a trade association of firearms dealers, for example, that has a lot of material online that's already ready-made. And so basically, these are the topics of training, but it doesn't require DPS to create any training. You're just relying on things that other entities have put together, including trade associations representing these very dealers. So it's, I think Senator Hagan has a question.
Yes, you may ask a question. Would you? Yes.
So, thank you. So it's under section 3 here, the firearm dealer employee training. Does this mean the employee, as mentioned in part 1, just above it, like a few lines above it? Or does this mean every employee, like Cabela's has a lot of employees, or LL Bean? So is this referencing the one just above it with people who are going to handle?
That's my intention. And if that's not clear, we should clarify that, because I agree, people who work in fishing, for example, don't need to, unless you're fishing in a, shooting in a barrel. Which
okay, thank you.
Sure thing.
Appreciate it.
Okay. And so this requires new employees as well as to receive this training within 30 days, and then existing employees to get that every 2 years thereafter. Then we get into maintenance of certain records. Oh,
yes, go ahead, Representative Crusoe.
Thank you. Your A through F. Did you come up with those because this is what is included in the approved firearm dealer employee training that currently exists?
So that required training does not currently exist. These are topics that I think are important for employees to be aware of, and topics that are identified in other laws.
Well, in 3, it says approved firearm dealer employee training. The department shall make a list available on its website, a list of approved training courses and materials. I'm assuming something already exists that they can pull from, which is what you had just said that you found out during the public hearing.
So a number of entities have existing resources that are not currently required in state law, but that exist in the world. For example, there's a really good website of licensed firearm dealers that has a lot of information. Similarly, so for example, the one that addresses mental health issues, there is an organization called the Gun Shop Project that has training materials online related to recognizing concerning signs of someone who's coming in to buy a firearm, and multiple states, Indiana's coming to mind, but when you go to that Department of Public Safety website, there's a link there linking to that Gun Shop Project training.
Right.
Does that
So,
answer your question?
yeah, so A through F is already in existence, is what I'm trying to say.
Oh, now I understand what you're saying. I believe that's correct.
Okay.
Yes.
So this could be satisfied by going through that list and we're not gonna have them recreate.
Exactly.
Okay.
Yeah.
Thank you.
I mean, I think it would be part of someone's job in establishing this to go through and watch the videos and make sure that they, in the department's view, are, satisfactory. But then once that's established, there would be a link provided. And I'm going to get to the end. Basically, in terms of startup, what's required of DPS is to make a landing page on their website where they're linking access to the background check, to the training resources, to the annual certification form. And then once that's established, there's not an ongoing, an ongoing requirement to develop those. That makes sense? Okay. Representative Poirier.
Thank you, Madam Chair. I'd just like to know with these trainings, I know for like state licensures and things like that, when you have continuing education, there's a reporting from where you took the training that, yes, you completed this. How is that going to be tracked with this bill for employees that need to take these courses at the start and then every 2 years? How is that going to be tracked?
We're going to get to that a little bit later in the bill, but the compliance is entirely self-certified by the gun shop. So they are signing an annual certification that they are in compliance with these requirements. And then if there is a violation of that, they're subject to civil penalties ranging from $100 to $500.
I was now, it was a violation.
Can I ask you a question? So would it be similar to, I know that right now under Maine law, employers are required to give annual training to prevent sexual harassment. And the employers then are required to keep a list of everybody who has gone through that training to prove that they complied. And then if the Maine Department of Labor, if there is an incident of sexual harassment, the Maine Department, or for other reasons, the Department of Labor could ask the employer to see the records of training simply to establish that the training had or hadn't happened. And would this be a similar system, but with the Department of Public Safety in place of the Department of Labor?
That's exactly analogous. Yes, the burden is on the employer to be implementing that, tracking that, and certifying that they're in compliance.
Thank you. So I want to recognize Senator Hagan, and then we'll get back to you for another question.
Thank you. In education every year, we had to take these, watch these videos and take tests as you go through. Targeted solutions is what it's called. Is there any accountability on this so that you took the video online? How do I know you did it?
So the gun shop dealer is certifying that they've done it. And if the department has cause to investigate and is concerned that there's a problem going on, this gives them the authority to look into it.
Okay.
But there's not any kind of annual inspection or licensing of any kind. This sort of goes back to what I was saying at the beginning, is that this isn't intended to be a gotcha situation. It's intended to establish what are best practices and good practices to promote public safety. And I would think that business owners would want to comply with that. It's part of like our culture of responsible gun ownership in our state. People want to do the right thing.
Can I do one follow-up? It's on this.
Yes, and then
pertains to this.
Representative Caruso.
Go
So
ahead.
if I go down to F, and this is a question I would have had
Mhm.
for this one, for the regular bill, but it's still here and it's not crossed out. Any reasonable business practice identified by the department, is that listed?
Is that listed?
Any reason, responsible business practice, thank you. Can't read. Identified by the department, that seems really vague.
It's intended to give the department authority to add something if in the course of their enforcement, they're finding that there's an issue, for example, and they want to provide additional training, they have the option to do that. I didn't presume to be able to identify every possible topic.
Representative Caruso?
Thank you. Are you aware, are there costs associated, with these, with A through F or any of this treat? I'm wondering if the fiscal impact to the dealers that would be imposed by this regulation.
So the materials that are available that I found and that I've talked about with DPS are all free of charge. They exist right now, and other similar agencies across the country are linking to them. They're for that purpose, and they are created by the industry. They're created by the dealers and the manufacturers. So it's, you know, firearm informed. It's being presented by the people who have to comply with it. That makes sense?
Yes, Representative Babin?
Sorry.
Thank you, Madam Chair. Couple questions on the liability issue. Let's say like a Walmart. Would they have to go through all this training for each person that comes in to buy a firearm and spend the time there to
So-
instruct, like they, how to recognize, identify, how to recognize, identify, respond to, and report individuals who intend? How do you tell that? Let's say an employee at Walmart could be, if I go buy a gun at Walmart, it could be a different guy that maybe works in a different department, comes in, sells me the gun, manager comes in, signs off, we're done. How
So
would
this
it
is
be applied?
intended to require the training just of employees who are specifically in that department and engaged in the sale, not everybody at
Okay.
Walmart.
Okay.
And if I could just further out, this doesn't impose any civil liability.
Okay. Okay, that's my other question on the liability issue. If there's an issue, can they go back on Walmart?
This does not establish that. There may be some other claim under Maine tort law, but this does not create any civil liability. I think that's a really important point. So thank you for raising that.
Additional questions at this juncture? Please proceed.
Okay, so that gets us through employee training. Then we get to maintenance of records. These records requirements are, I believe, entirely already required under federal law. So this isn't and we'll go through the chart and or consistent with federal law. So I don't believe that creates new requirements. Then we get into reporting that follows federal law, as you can see. And then we get into compliance and the idea of enforcement, which has come up a couple of times. It does not require the department to do any inspections. All it does is give the department authority to investigate if they have reason to believe that there's a problem. It does require the department annually to submit a report that describes how many entities have submitted the compliance report. So that could be interesting if we know that there are 400 and some licensed dealers and they're getting 200 reports. That would tell us that people are not complying on a widespread basis, or if it is, being complied with, I guess, basically. And then also to characterize any inspections or any investigations that they've done in sort of an anonymized way. So it's not revealing information about a specific investigation that might be underway, but would help the public and the legislature understand how it's being enforced and implemented. Oh, I am. So on page 3 of the bill, under compliance, section 507.
Did you have a question? And if so, could you please turn on your mic?
Sorry, I was trying to keep up with you. Is everything above compliance from the last bill, or is this new?
That's correct. It's following federal law in that section related to record keeping.
So maintenance of record, section 505
Mhm.
is, and 506 is federal law?
We're going to go through the chart because it's a little bit more nuanced than that of what is in law, what's in regulation, but it's very consistent with federal law. I'll just give you an example. Let's see, like in 505-4. Well, can we wait till we get to the chart? I'm afraid of just jumping back and forth.
Is that okay with you?
But
Representative?
it's consistent with federal law, but I'm happy to go through it with you.
Senator Hagan?
Thank you very much again. Can I go back to page 3 at the bottom, letter E? This is part of my notes that I wanted to ask about.
I think
know
that's
we just
page
went-
2.
Page 2, yeah. What did I
Okay.
say? A different one? I was just looking at it.
It's okay.
So now we're training employees how to educate customers on gun safety practices, including the safe handling and storage of firearms and ammunition. I don't quite understand this. It makes me, if I purchase a gun or a car or a candy bar, I'm not educated on safety practices. So curious as to why this is here.
I mean, respectfully, I would say that a candy bar, I mean, I know, I'm just saying improperly stored or made available to children isn't a dangerous item.
Right, I'm just giving
Potentially.
examples, but this seems curious, party on educating customers on gun safety. And then not limited to safe handling and storage and firearms and ammunition. It seems excessive for employees to have to educate. If I go purchase a firearm, I don't really want to talk to anybody. I just want to fill out the extensive paperwork and get out of there with my firearm so I can go hunting or what have you. What happens here? How does this happen? What's the process with which I, as the employee, have to train you on these things listed?
Go ahead and answer.
So this section relates to the training that the employee has to get. It does not specify what the employee then has to go do with respect to the customer. I would also add that Maine law already anticipates advising purchasers of safe storage requirements, because in law, there is a requirement that there is posting around safe storage in
Yeah,
a facility. There's also a requirement to make available training on how to use locking devices. So that's already anticipated in
would
law.
we cross
just
out the word? oh,
Hang
sorry.
on 1 minute. I just
Yeah.
want to ask, because I know you're talking back and forth and I don't know. I was very patient to make sure
Yeah,
Senator
sure.
Hagan finished
I
articulating his
appreciate it.
question. And I want to know then, Representative Kuhn, were you done providing your answer?
I think so. I just want to clarify that this section relates to the training that is provided to employees.
So would we strike out the word educate to make it a cleaner right?
I think that's something the committee could discuss. As I said, I think that the provisions in Maine law already anticipate that the dealer has an important role to play, especially if someone's coming to buy, perhaps a first-time firearm owner, has an important role to play because they know a lot about their products and they know how to safely use them. And I think they should be empowered to pass that on.
Well, I'm just only worried about, this is a new law. So this law will have to be observed and obeyed by the people of the state of Maine. So even though there are other things, when employers are looking at violating any kind of gun, things, they don't want to violate anything, lose their license. This could be complicated as if there's already stuff in play. I don't know why we would have that. So that's for later today, but
Yes, let's take that up perhaps in discussion. Also, I'm wondering, Representative Kuhn, if you have examples of the kinds of materials that would be linked under paragraph E to give us a better idea of what that might entail.
I can certainly send a link around if that would be helpful.
Okay, thank you.
I just want to clarify too, that the remedies in this bill could not possibly result in a dealer losing their federal license. That's not in any way possible under this.
yeah, I like to have them for hunting, but I don't know anything about, the FFL stuff and what they have to go through. But, I would be concerned on these things. I think of chainsaws or other lawnmowers that are dangerous. And with guns, I don't get education on my Husqvarna or my DeWalt cute little thing. But anyway, probably for later, we strike that
Yeah,
out. Yeah.
let's keep going through the proposal so that we understand it from beginning to end. And then I know we have the chart that will address Representative Poirier's question. And then we can have committee discussion. Yes.
Would you equate it to like when you buy a new car, they give you training on all the options and features and safety features in your car? Because, so I mean, I'm kind of looking at it that way, but I also see it as an opportunity for the dealerships to make money selling safety storage stuff when they educate people how to properly storage, or making money off of, you know, if people need lessons, because there are a lot of young people buying guns now. I know my girls are having those discussions and they don't know how to use them. They don't know how to store them. So I'm kind of thinking that I'm looking at it as a, like, it's not like you have to educate every customer. Is it just saying that it's, if you have a customer that asks you, you have to know how to answer those questions? Is that what the intent of that is? Or do you have to do it with?
I don't think it puts, thank you for that question. I don't think it puts a burden on whether the customer has to ask or not ask, but it ensures that the employee is knowledgeable to
Right.
be able
But I
to
guess I
offer that
worded that wrong.
information.
The employee does not have to educate a customer who does not ask and clearly knows. But this bill is saying that the employee has to be educated enough so that if somebody who doesn't know these things asks, that they have to be able to give them proper, safe information. Is that what it's saying?
I think that's accurate. Yeah.
Okay.
It's
I
it's
just
to make
wanted
sure that the employee is knowledgeable,
Right, okay, so I
not
just
to
wanted to make sure,
necessarily
and that's only if
inform the employer.
it's needed
sorry,
from
the customer.
somebody who doesn't know. Okay, I just wanted to make sure I was understanding that.
Yeah, thank you.
We could continue. I
Okay.
think we were on bottom of page 3.
Bottom of page 3. Okay, so an annual report so that we can see how the law is being implemented. Then we get to violations. And so these are civil penalties, ranging from, a $1 to $500. And then going up if someone, is repeatedly, out of compliance. And then, section.
Yes, go ahead with your question.
Thank you, Madam Chair. Then this is very helpful to allow questions during the process of this, so thank you. So Representative Kuhn, you had mentioned just a couple minutes ago that someone not complying with these training laws wouldn't in any way result in them losing their federal firearms license. My concern, I think, is the very top of page 4, under false certification penalty. It says a dealer may not falsify information or contents in the compliance record required by subsection 1. A person who violates this subsection commits a Class C crime, and a Class C crime is a felony, and a felon can't possess a firearm, much less deal them. So someone could potentially lose their, not potentially, they would lose their firearms license if there's non-compliance.
Thank you for pointing that out. That's addressing a situation where there is willful noncompliance, where someone is deliberately falsifying their compliance report.
Right, so non-compliance
Just,
will
I
result in a
think that
federal.
could you please
losing
just let
FFL.
Representative Kuhn finish her statement?
Of course.
Thank you.
So, yes, a willful noncompliance is a serious offense, in my opinion. And in terms of the consequences with respect to their license, their federal licensure, I'm sure we could get more information about that. But thank you for clarifying that.
Okay, thank you.
Okay, then we get down to the civil violations. Then we get into the notice to purchasers upon sale of firearm. One change that is recorded here is asking the department to basically create the posters and make them available on their website. This is very similar to the Department of Labor, which has required postings. And it just would result in more standardized notice. Let's see, 5092 clarifies that those same notices need to be provided at a gun show. as well as at a brick and mortar. At the top of page 5, we're eliminating rulemaking responsibilities from the Department of Public Safety. And I guess not replacing, but requiring the department to post resources on their website. So links to vendors who can perform this criminal history background check, similar, as I said, to school volunteers, links to authorized training materials, links to posters, so that dealers can just print out from one place what needs to be posted instead of having to create the wheel themselves. And then a link to the annual compliance certification form.
Thank you. And I see that Senator Hagan has his hand up. Go ahead.
Thank you. So on number 2 on page 4 at the very bottom, you said applies to gun. I can't tell if that's crossed out. Gun shows?
It's crossed out.
Looks like gun shows is crossed out.
Let's have Representative Kuhn read it as intended. Because, yeah, it's a little unclear with the shading as well.
Yep. So it's posting required, period. The sign described by this section must be posted at all entrances of a gun show and by a dealer at all firearm points of sale. So it's just clarifying for the dealer that it applies wherever they're engaging in sales.
Yes, Eli?
I'm going to clarify just a couple other changes that Representative Kuhn did not mention, but were small kind of technical things as you were going on. The first of which is if you return to page 3. So this is when we were talking about employee training. There was a change that instead of having that training be completed prior to employment, its training is now required within the first 30 days of initial employment. So that was just a change based on conversations with the department, et cetera. And then the second change is in that reporting requirement at the bottom of page 3. Again, there were some discussions of what information is being reported, and it was clarified. You'll see there in that shaded bit that any summary information of investigations is non-identifiable. And so it's not any reporting of an investigation that was conducted is not going to say the department went to Representative Henderson's place of business and did this. It would, in a more aggregate way, describe the types of investigations that were conducted, really as a means of looking at, what types of things are happening versus who is the investigation being done to.
Thank you, Eli. Representative Sinclair?
Thank you, Madam Chair. I appreciate your continued work on the bill, Representative Kuhn, and I think it's a much stronger bill now. I want to follow up a little bit on your conversation with Representative Henderson. What I understood your response to be, you used the word willful, and yet there's no mens rea at all in the current amendment text. And I'm concerned that then when looking at this, a court might say, well, heck, they didn't provide any mens rea. Maybe recklessness goes in there as well. What I would suggest, if you're open to it, is an amendment that essentially would change it to say a dealer may not intentionally or knowingly provide false information or contents in the compliance report required by ... a person who violates the subsection commits. And that way it would be clear that you're really looking for those more flagrant violations rather than a simple slip.
Yes, go ahead.
I really appreciate that. I think that clarifies that a dealer is not going to accidentally or mistakenly fall into this category. It is intended to really be a net for an individual who's intentionally falsifying. So thank you for that amendment. I appreciate that.
Could you please restate that, Representative Kuhn, for the rest of the committee?
So if we're at the top of page 4 in paragraph 4, there would be an insertion of 3 words. So it would say a dealer may not intentionally or knowingly falsify information or contents in the compliance report, to clarify that it's not something that could happen negligently or by accident or by mistake. It has to really be a willful violation. That's what was intended there.
Thank you, Representative. Other questions, comments? Representative O'Halloran?
So that has to do with the required training, correct?
That has to do with everything that they're certifying in the annual compliance report.
Would it be better to do like a tiered offense rather than just starting out with like a class C crime? Would it be better to, you know, if somebody didn't finish all their training or something like that? I can't think of specifics, but would it be better to start out with a fine, like a graduated type penalty rather than starting with a class C that would, you know, make their ability to sell guns completely gone on one offense? I mean, especially where this is a new bill.
Yeah, I think that's anticipated that if an element is missed, it's subject to a civil penalty of $100 to $500. This is to address a situation where someone knowingly falsifies its submission
Can
to
you
the
give me an
department.
example of what type of submission that would be?
So they fail to have any locks on the doors or any safe storage in their store, and yet submit a certification saying that they've secured their place of business. Or whether they've taken reasonable steps to secure their place of business.
Thank you.
Senator Hagan?
Thank you very much. When we're done breaking down the amendment, and whenever you feel it's appropriate, could we do a corner caucus for a little bit to sort of get it in our head? And at some point before we go, and up to you, no time frame for me. I would like one of the experts in the gallery, or two or three, talk about, well, I'm worried that all I hear from these dealers is if we make one mistake, we lose our license. So I'd like to hear from those that are there, or the lawyers that could maybe talk to it after we come back.
Yeah, we can
I'd be
certainly.
nervous
yeah,
about.
Understood. We will definitely do that. What I'd like to do is we'll take a couple more questions, but I think that our knowledge will be enhanced by going over this purple chart. And I do think it's tied into the, like, what are the risks to dealers? And so Representative Caruso, did you wish to ask your question?
I didn't, there were some officers here and I don't see them here. I don't know if they were going to be available for questions, and you know, I'm not a dealer, and so like I would want to hear with regards to what you were just speaking about, Representative Kuhn, locking the door. So I can't imagine there's a place that doesn't have a lock on their door. But are there any stipulations? Like, it seems very general what's written in here, and I would want to have an interpretation on, you know, who doesn't have a lock on their, especially their business, who would, like, nobody would want their inventory stolen. So everyone should have a lock on their door. Is that sufficient? Or that, you know, gun cases, and safes, when they're open, a lot of times the guns are visible. They're not going to be in their safes because they're open for display. So I just would like to have some clarification on what is expected.
Yep. So there is a specific provision that relates to whether the premises and the inventory is unattended. So if the person is working and there are firearms out, that's attended. So no further requirements would be imposed at that time, as I understand. This is really for when the premises or the inventory is unattended, whether that's in brick and mortar or at a gun show. And this reasonable standard is used in other states that have this same or similar law, because it really varies according to circumstance. And that's what the reasonableness standard allows us to do is look at what is reasonable to an average person under the circumstances. And this is something we deal with in this committee under a lot of different contexts, right? So if you're Cabela's and you have a very substantial inventory, and you know, the means to really put in extensive security measures, then you would be expected to do what's reasonable under those circumstances. If you're a much smaller vendor with handful of items in your inventory, then you would be expected to, in all likelihood, have a lower level of security in terms of potential alarms and locks and, you know, all the different options that would be available. So it's a standard that I didn't make up. It's a standard that came from other state laws.
Representative O'Halloran?
I just have a curiosity question. So, one, is this already covered under federal law? And two, if you have an FFL business, aren't there insurance requirements surrounding locks and procedures and all that stuff? I would have to think.
That's an interesting question. I don't know the answer to that. That might be a good segue though.
Yeah, let's
To
go
go to
over the
this.
chart.
And then I'll
Please.
just wrap up and we can let other folks talk. So we'll go through the primary elements are listed in the left-hand column, and then it shows what's required in current Maine law, what's required in federal law, and then what's recommended by ATF or NSSF.
What is NSSF?
That's the trade association.
Thank you.
For dealing.
Thank you.
National Shooting Sports Foundation.
Thank you. So that's the industry itself. Okay, so physical security, there are no requirements currently, but it is the industry recommends to its members the items suggested here in the third column, and those, some combination of those would probably amount to reasonableness depending on the extent of your inventory and probably your location also. Physical inventory, again, no requirements, but it is recommended by the industry, and there are those standards. Employee background check. Federal law requires the manager or the owner of the store, the person who's ultimately responsible, to pass that, but not every employee. Although the industry and ATF does recommend that be part of it. Minimum age for employees is not currently in law. Employee training is anticipated in ATF regulations, but not otherwise in law. The records of sales is required under federal law. Loss and theft reporting is required. Inspections for compliance. There is state law that's a little bit more limited, where it has to be announced in writing, can only be commenced pursuant to a criminal investigation. Under federal law, ATF can inspect without that limitation. And the bill that's before you proposes the ability to inspect during business hours. So here's an example of a difference in the record keeping, where the bill requires FFLs to maintain records of traces. And under federal law, they're required to just respond to traces, but they don't have to keep a record. So that's just an example of like a nuanced difference, but it's something that they do have to do under ATF. Educating gun buyers on risks. As I mentioned, state law does anticipate providing some of this information to customers. Similarly, under federal law, there's a requirement to distribute information, and under ATF and NSSF recommendations, the education goes further than that and is more similar to what's required in the bill. Multiple pistol transactions are covered under federal law and required. An annual certification of compliance is, of course, new to the bill. What I hope that this chart demonstrates is that much of the activity that is required under the bill is already required or similar to what is required under federal law, which I think is important for us to touch on. Like, why are we putting into state law things that are already required under federal law? Are we creating an overlapping system? And I would say the answer is yes. And we do that in a lot of different ways in state law, where something can be a crime under federal law and a crime under state law. That's not uncommon. And what it does is give the ability of Maine law enforcement to address known concerns, even if the feds don't want to act. And I think that's relevant because there's data to show that ATF has historically been under-resourced. I mean, your average FFL can expect to be inspected about once every 9 years. Now, when there is an inspection, about 40% of the time they find a violation, but it's not something that happens regularly. And that was the case years ago. And since 2025, there has been further rollbacks of enforcement activity. About a year or so ago, there was a rescission of the zero tolerance policy at ATF, which had led to mandatory license revocations for certain willful, deliberate violations of ATF rules, and that is not the case anymore. That is under a more permissive enforcement policy. There have been reductions in force. There have been reassignment of agents to work on other enforcement priorities of the administration. And so, as I said from the beginning, this is not intended to be a gotcha. It's intended to give Maine law enforcement the authority to investigate if there's reason to do so. It's not to create hassle for firearm dealers. And in fact, we talk a lot in the committee about the responsible gun ownership culture in our state. And I really believe that dealers want to do the right thing. They want to keep people safe and provide helpful information for consumers. And I think the goal of this is to incentivize that and to get that into law so that the state can act if needed.
Thank you. During the middle of your discussion, saw Representative Henderson's hand up and then Representative Poirier. Did you wish to ask the question? It was second page of the charts where we were when your hand went up.
Yes, thank you, Madam Chair. So specifically around the inspection for compliance. So that is found on your amendment, page 3, 507, compliance. Paragraph 2 under inspections, it says a dealer shall provide the department with full access to the dealer's premises for an inspection. The department is authorized to conduct an inspection by the dealer. In your discussion and kind of like in finding an amendment and framing how you wanted the bill to look, was there ever a time where the topic of dealers who have this, run this business out of their homes, how giving local law enforcement at any point access to people's homes for inspection? And I think I view it somewhat different than ATF because ATF has access and it seems as though, right, they would have access to the premises. I don't have that federal law in front of me. My concern is ATF only enforces firearms regulation laws, where local law enforcement would enforce all other kind of laws. So they may come in contact with things that they find in the home that would make that individual subject to other charges brought against them that wouldn't normally. Like, I feel like this might be an avenue into people's homes that law enforcement could use. And I'm just questioning the Fourth Amendment side of things with allowing local law enforcement to enforce all kinds of laws access into people's homes. Is that making sense?
Yeah. Can I just interrupt with a question? How, do you have any way to quantify how many people have firearms businesses in their homes? I'm just curious.
So I had, I know when I purchased my firearms, there's the Palmetto, I think it's Palmetto State Armory. I'm not plugging for them. That's just who I purchased my firearms parts through. When I purchase a lower for like an AR build or something, they give me a list of local dealers. Many of them, there's one in Andover that has one out of their home. The guy I use is at a Dixfield. It's in his home, in the basement of his home. I know that there's a family in Jay that he is a gunsmith as well as a FFL dealer. They have their business in their home. So this might seem like anecdotal evidence, but around me in the rural part of Maine, there's a significant amount.
Thank you for clarifying that.
So you're anticipating a situation where they would come in to inspect and then maybe there's illegal drugs there? Is that, and you wouldn't want them to be able to bring charges on that?
So I think that's going a little farther than what I was saying, but that there would be no other recourse for law enforcement to enter the home. That this would provide them an avenue to come into the home and maybe they would see something or witness something that would bring probable cause, maybe not overwhelming evidence, but probable cause to open an investigation, to collect that evidence and bring that person into custody where law enforcement wouldn't normally have access to the home.
I mean, I'm thinking of, well, I guess I want to give that some consideration.
Yeah.
Representative Poirier and then Senator Hagan.
Thank you, Madam Chair. My question had a lot to do with that, but I went a little further. Just to piggyback on what Representative Henderson said, I can think of 5 off the top of my head dealers that between just Skowhegan and Madison that are in their home. So it is going to be a larger, if you were to go out there and poll who does it through their home, and I think it's going to be a larger number than you anticipate. But my question also, to go further than just the inspections, would also be the security part of this when it is at a person's home. I question that too, because you're talking about very small dealers, but they're going to be held to the same standards as a larger. So that's kind of concerning too.
Let's let Representative Kuhn address that. I know you spoke to it a little bit earlier.
So this is exactly why the reasonableness standard is helpful instead of requiring every dealer to have window bars. Because if it's in someone's home and they have a small inventory, they could just secure their inventory in a lock device or with locking devices on the firearms. So that would be a reasonable accommodation for someone who has a low level of inventory in their home, as opposed to armoring their whole home.
Is there going to be any kind of definition as to what is reasonable? Because what you consider reasonable, somebody else may not.
I mean, that's true in many, many cases, areas of law that we deal with, where reasonableness is something that ultimately it's up for interpretation deliberately to be flexible and to provide for particular circumstances.
Can I just add that one of the training components where there's the list of resources is how to prevent, respond, or report theft or burglary of firearms and ammunition. And so I do think that it's not, I could envision a situation where there's, one recommendation for Cabela's and a totally different recommendation for a standalone firearm store and a totally different recommendation for someone in their home. I think that when we're thinking about the requirements, we should keep in mind that there are going to be resources to comply with those requirements. Yes, Representative O'Halloran.
So, she actually had my question that I wanted to ask under the physical security, because even in my area, there are many that have them in their home. I think it's a lot more common than maybe people realize, and it just wouldn't be possible. But so are you saying that there would be some sort of resources to help some of these dealers to be able to secure their firearms properly? And I know, like, when we heard testimony from the state police, when they sometimes have to take guns in domestic violence situations, it seemed like the majority of them were just from people owning guns were several hundred. I would imagine I think even a small dealer is going to have a few hundred variety of firearms in their home, not just like 20, but probably 300 or more type thing. So I do, like, how do we I'm not doing a good job asking my question again, but I guess to get to Representative Poyer's thing, I mean, I think that there needs to be something to define that, because it could be interpreted so broadly. Like if a small dealer had 500 guns, I wouldn't consider that to be a large inventory. Like, I'm not sure how you define that. Not sure how to
Yeah.
ask the question.
No, it seems like more like committee discussion. So before we like dive into discussion, is there any more questions? Just straight questions. Representative Caruso.
Thank you. Representative Kuhn, you had mentioned earlier when you were going over the chart, there was you had mentioned a stat about 40% of violations. Is that in the country? Is that in Maine?
That's a national statistic.
Okay.
Yeah.
And I'm not aware of this being a problem in Maine. Usually we're pretty, you know, as far as I know, I'm not aware of any problems. Are you aware, do we have a big influx in problems that would warrant this? There are a lot of violations. Is ETF having a problem here? I'm just not, I haven't heard of any.
Yeah. Certainly there's a great number of stolen firearms that
From FFL?
let's get some information from experts in the room. That is what the whole point of the bill is. It is to help prevent theft. Or one of the primary objectives, I should say.
So I would like that information,
Yep.
like how many dealers are having stolen firearms? That would be really, really helpful.
Great, we can get that.
Okay, so I see a couple of other hands up and I want to be cognizant of the fact that we have folks sitting here in the committee room who might be able to answer some of these questions as well. So we're going to take one question from each of you, and then if we can turn to some of the people who've been waiting all day to answer our questions. Senator Hagan, go ahead first.
Apologies to the to the gallery, but I'd like to corner caucus before we ask questions, because Representative O'Halloran said something that caused me to have a question, but I don't want to ask it till I've thought it through. And then talk about some of the things in here. And then when we come back, we can be loaded with what I would consider better and more intelligent questions.
Thank you for that suggestion. And Representative Poyer?
Thank you, Madam Chair. Just going back to the line of questions that many of us had, when we're talking about an FFL that's in their home, if law enforcement goes in and does spot inspection, is there something to clarify that it's only for firearms that are written in their inventory? Because obviously, if there's a firearm dealer that's anything like me, if I'm home alone, my gun does no good locked up in a case to protect myself. So they may have firearms in their home, in their living quarters, that aren't locked in a case. So if it's, you see where I'm going there, I want to make sure that they're not going to be penalized because they're 9mm on their nightstand, but it's not part of their business inventory. It shouldn't overlap there.
And I think the bill only anticipates inventory related to their business, not personal
Will it
possessions.
clarify that though?
I think it is clear, actually. but
Yeah, it does
it
say
should be.
the inspection would be, first of all, during regular business hours for that premises, and to determine compliance by the dealer with the requirements of this chapter. So it wouldn't be, unless they're selling firearms out of their bedroom, there wouldn't be any inspection in the bedroom. Let's, I appreciate your suggestion, Senator Hagan. Thank you very much. I'm also cognizant that it's 12:25. Do we want to take a break until 1 or close to 1 so that people can get a lunch and then digest this information and lunch and come back at 1? Okay, so we'll see everyone at 1. And for those who might be waiting for LD 374, we will not take that up until at least 1:30. Thank you. Committee members, we're going to get started. So if you could please return to the horseshoe. Thank you. We're going to resume our work session on LD 370. Nope, not 374. 1821, excuse me. Thank you. We're going to resume our work session on LD 1821, and I have a suggestion about how we might proceed. And that would be, we've heard a lot of information primarily from members of the committee and the bill's sponsor. We do have folks sitting in the committee room who have information, I think, that they wish to share with us. So my suggestion would be that we spend about a half an hour hearing from those folks and asking them very specific, kind of targeted, pun intended, questions about the matters that are still unknown to us with regard to either this legislation or how it would impact firearms dealers. And then that we table the bill and we take some time to let the bill sponsor take in all of the information she's learned from all of us and see what the next steps are. I'm estimating that we would have a work session next week on this bill, because again, we're under a tight time frame to wrap things up by the 30th of January. And so we would, if we tabled it, would just be for a short time frame. And so with that, just a minute. Give us just 1 minute, everyone. And as a scheduling announcement, our schedule indicates that we'll to have a work session on LD 374, an act to provide comparable compensation and benefits for deputy and assistant district attorneys, assistant attorneys general and public defenders, starting at 1. And we're not going to probably take this up until 1:45, I would suggest. We're probably about 45 minutes behind schedule. Thanks. And the analyst reminded me that also on our schedule for 1:00 is a discussion of the sexual assault forensic examination kit tracking bill. And we will also discuss that. We'll take both of those up, not at the same time, but close to each other at approximately 1:45. Committee members, we're back on resuming our work session on LD 1821. And Senator Hagan has one question that he thinks that Dan Riley, who has been waiting patiently in the committee room, could answer. Would you please join us at the Horseshoe?
Thank you.
And if you could introduce yourself, and then we'll let Senator Hagan ask his question.
My name's Dan Riley. I'm an attorney with a firm of Norman Hanson Detroit here in Maine. And I appeared today on behalf of my client, the National Shooting Sports Foundation. I testified at the public hearing and we provided written testimony at the public hearing in this bill. Shooting Sports Foundation is the trade association of firearm manufacturers and dealers.
Thank you very much for introducing yourself, Senator Hagan. Actually, I think that Senator Talbot Ross would like an opportunity to introduce herself.
I appreciate that, Madam Chair. My name is Rachel Talbot Ross. I represent Senate District 28, which is on the peninsula of Portland. Thank you very much. Welcome, everyone.
And Senator Hagan, do you want to go ahead with your question?
Thank you very much. I'm just a little concerned about the C felony part of this particular amendment. It's on page. Where are you?
It's the false.
On page 4 at the top. So that seems a little aggressive to me. Could you talk about that?
Well, as you know, having served on this committee for some time, Class C is a felon. So this is not a civil violation. It's a big deal. And if you are a firearm dealer, you are among the most highly regulated industries in the country. So I think it's very important. I know the sponsor has talked to you about the fact that her intention is not that this be a gotcha type bill. I'm just seeing this amendment as you are for the first time today. But Class C felony is a big gotcha. That's a problem.
Did you have a follow-up?
Yes, thank you very much.
Go ahead.
So in this bill, in the work session, while we fine tune things, what would the people that you serve recommend for non-compliance as written in this section 4 of the bill on page amendment on page 4?
Well,
I'm sorry to interrupt, but I just wanted to clarify, Senator Hagan. Are you saying non-compliance with the provisions like the record keeping, or are you saying a violation that involves intentionally or knowingly falsifying information on a report?
Well, in my notes as Representative Kuhn was explaining things, talking about woeful non-compliance or willful non-compliance. And then with the sentence in beside number 4, I was curious as to, it just seems like a Class C crime is punishable for up to 5 years in jail. It seems excessive. So I just was in not being an attorney, I thought I would ask the guy who certainly is, what his company would, or group, how they would feel about moving it down to a D, or keeping it at a C, or non-compliance is non-compliance. That is against the law. So.
Okay, thank you.
That's about all I got here.
I think the best way I can answer your question, Senator, is to point out that at the public hearing, my testimony and my client's testimony was that much of the original bill conflicted with federal law. That's been discussed today by the sponsor and with her attempt to amend her original bill. So the federal law requirements are what my client and its members are concerned with and follow on a regular basis. The second issue that that the sponsor raised that I talked about in my written testimony was that the training program that the sponsor has said she's interested in already exists in the form of Operation Safe Store, which was an initiative that my client began in 2018. And if you look in your files, you'll see that since 2018, that initiative, which is an industry initiative of the National Shooting Sports Foundation, has produced a 25% reduction in the number of stolen firearms nationwide. So that's just since 2018. So my client believes that the federal law that its members already comply with and Operation Safe Store initiative are sufficient. And you don't have, as Representative Caruso pointed out in her questioning earlier, you don't have any real data on any proliferation of stolen firearms here in the state of Maine. That's probably information you could get from the state police if you were to ask for it in an annual type report. The last thing I'll say is that if you look in your file from the public hearing, Trooper Casavan testified in opposition to this bill and said that it would require an enormous increase in headcount. I'm sure that the amendment that the sponsor has drafted is intended to try to avoid a fiscal note, reduce the costs of that. But this was not something that the department wanted at that time. So I'm not sure if that's directly answering your question, but that's the best I can do right now.
Yeah, thank you. And so I do want to suggest that we're going to question Mr. Riley and Mr. Trahan until 1:30. And so with that, those timeframes in mind, because as I mentioned, we will have to have a second work session on this amendment. Does anybody have any more questions for Mr. Riley? Go ahead.
So are there federal guidelines on how FFLs have to store their guns now?
They're not guidelines. They're, as I understand them, they are federal requirements.
Oh, okay, so there are federal requirements on how.
I
things
don't
are
have those in
stored.
front of me right now. I could do my best to get those to you for your
Okay.
next work session.
Okay,
Could you please email a link to those to our legislative analyst, Eli Murphy, when you
If I'm
find them?
able to get them for my client by your next work session, yes.
Thank
could I
you.
ask just one quick follow-up?
Yes.
So would it be possible to have a situation where somebody's meeting federal guidelines, but then say somebody from the state police, the Department of Public Safety, however that pans out, could go in and then say, well, I don't think this is sufficient, and somebody could be penalized that way? Or do you think it's very clear?
Well, under current law, as has been pointed out, the ATF has the regulatory authority over dealers. Yeah, so in the situation you're talking about, were language similar to this amendment to become law, then you would have that type of dual situation, which is obviously something that my client and our member dealers would be concerned about.
Thank you.
Any additional questions for Mr. Riley? Seeing none, thank you very
Thank
much. Mr. Trahan, could you please join us as well? And so again, committee members, we had a lot of information needs earlier on. So if there are questions that you wish to present, please raise your hands and I'll call on you. Yes,
Information.
Representative O'Halloran.
I was wondering if we could get like a number on the stolen firearms, and then also like how many FFLs have been robbed in any capacity in the last few.
That sounds like perhaps a question for actually, why don't you ask the questions of Mr. Trahan?
Oh,
And then if he has the information, he can,
Oh, I
I'm sure
didn't know
would,
he would have that.
he may have access
Oh,
to it.
okay.
You can ask him.
I'm sorry.
And I just want to give you a chance to introduce yourself and welcome.
Yeah, my name is David Trahan. I'm the Executive Director of Sportsman's Alliance of Maine Institute for Legislative Action. And Sam is a licensed FFL dealer. We have been for the almost 15 years that I've worked at SAM, and I'm familiar with many of the procedures and required rules of ATF. I have had ATF audits, and it's not a very fun thing. When 3 ATF officers come to your facility to question you, it's very intimidating. And I do think that they do a very good job policing what they do. So with that, I'll take any questions about the work that we do. And by the way, we do not sell firearms. We just do raffles, which we sell raffle tickets or seek donations
I'm
from
going
our
to just,
members.
because our time is limited
sure.
and that's not directly related to the bill, I'm going to give, did you have additional questions, Representative O'Halloran?
Yep,
Can you turn on your microphone and just ask?
I wanted to, do you have the information on how many firearms are stolen in a certain period of time from
Well, as
homeowners and FFLs?
I do not have that with me. Again, didn't see the amendment until today. And I can tell you that in some parts of the country, it is significant. But we've done a good job here in Maine. I think
I was just thinking of Maine, not the rest of the
yeah, the thing about Maine is because we are so rural,
country. Yeah.
I'm sorry. I think she's
Yeah,
asking for data.
Just for the
I
data.
don't have the
Okay.
numbers. The state police may.
Okay, then I'll ask
That's why I'd
that.
seek
But
it
the
from
only follow-up, how often do you see ATF? How often have they been?
Pretty much every year.
Really? Okay.
Yes.
Thank you.
Other questions, committee members? Yes, Representative Crusoe.
Thank you for being here. So you just said you see them every year and you don't even sell guns.
That's right. We have a license. So they're coming to our facility to make sure we're complying with safe storage, that all the inventory that we've taken in is still in our inventory. We have to address where they went and the procedures in which we store those firearms. It's pretty extensive.
Yeah.
Most of what's in this bill, I think around the education and safe storage is already covered by ATF. And it's just really a duplication.
Could I ask a?
Yes, go ahead.
I was just looking in my file I know I had seen last session about safe storage and I'm sorry, I forgot, but could you explain to me again what that is?
Yeah, you had a bill to basically destroy all firearms in municipal state possession. And I had suggested that they continue to do their auctions, but put some of that money from the auctions into safe storage in a bill that already existed. Senator Shambo and I had worked on it, passed through the legislature.
But safe storage is for individuals and businesses?
Actually, that law called for safe storage in things like daycares, at-risk groups. It was supposed to be that safe storage education for the high priority areas, high risk areas.
So the ATF, when they investigate your facility, they want to see compliance with safe storage?
Oh, absolutely, yes.
Even though you're not a high risk, you don't have okay. Thank you.
Other questions, committee members? Let's give somebody else an opportunity. Questions? Not seeing any, go ahead.
Is the reason that you see ATF so often is because of what you do for business, not that you're a standard FFL, but because you're raffling and they have to make sure that there's on the stolen guns or if there's been used in a crime or things like that? Is that why you see them so often?
We see two entities. Because we do raffles, we also are regulated by the state police for our raffles. So they audit us and I've been audited. We were in compliance, but for our gun raffles. But
I
then
was
the
just
second
clarifying.
piece,
There's a
the
difference.
second piece, ATF is really looking to make sure that your inventory lines up with what's in your books and that you're
Right.
storing your firearms
Right.
properly.
But I'm just saying you're gonna see them more often than
Oh,
a
yes.
regular FFL person.
Yeah, and what I like about the ATF too is that if I call them and say, and I have done this, we had a cannon donated with a trigger mechanism that has me concerned. I called them, they looked at that trigger mechanism and said, yes, it's in violation of federal law and must be destroyed immediately. The relationship right now between ATF and the dealers is a good one. And it seems to me, from my experience, that they're trying to work together to make sure that the laws are followed. So I think ATF is acting totally appropriately in the way that they're administering the federal law.
Additional questions? Yes, Senator Hayden.
One that popped into my head from earlier, it was discussed a couple times, and I think I asked the question. Uh, If you violate any, if you don't comply with all state, local, federal law, they don't take away your FFL. They just, what do they do?
They put you on probation
Yeah,
and you have a period of time to correct your mistakes or your procedures. And then they follow up on that to ensure that you've done it. I would just add one thing. You just expanded background checks to advertise sales. If you do something that discourages the smaller ATF dealers in rural areas, you'll be limiting the places in which people can actually have those background checks done.
Anything else, committee members? Yes, Representative Crusoe.
I have a question for the committee. I haven't seen law enforcement here. They were here early this morning. They're not here. And I would like to talk to them the next time we meet to hear their stand. And also some dealers, someone to represent dealers to understand, this is all about them and I want to understand what it would take to go through records and like the applicability of this.
Yeah, we can have them come when we schedule a second work session, but I would just also encourage you, because this is not a public hearing, we're in the work session stage. And so this is really about relying on all the information that we got during the public hearing and then asking kind of narrowing questions. So I think we will invite them to the next work session, but I would just say, let's try not to have another public hearing.
No, just to ask the questions about the specific, because the amendment is different and I don't work as one, so.
Okay, thank you.
Thank you.
Madam Senate Chair,
Yes.
I would like to bring to your attention that this may be in violation of the current state law. If you pass this and you create a database in which all law enforcement have access, and that database being firearm owners in a FFL dealer's books, there's a state law that says that it's illegal to create a comprehensive database of gun owners in our state. We repealed that a few years ago. And it looks like this is restoring that law, almost identical to the law we repealed.
Could
You
you
might wanna look
just
into
simply,
that.
before you get up, and we do
Yeah.
appreciate your time today, can you just simply let us know which section of this draft you believe runs afoul of that?
Yeah.
And you can either email the bill sponsor, or you could let Eli know,
Yeah.
and preferably sometime today.
He's a terrific analyst and I can definitely work directly with him.
Thank you.
Yep.
Thank you.
Anything else?
We appreciate your assistance today. And next, we're going to hear from Margaret Groban. If you could introduce yourself, and then I'm going to go right to questions.
Okay, I'm ready. Margaret Groban. I'm a retired federal prosecutor. I also teach at Maine Law School's class on the Second Amendment, but I am not here. I want to be very clear, representing the Maine Law School. These opinions are personal to me.
Thank you. Okay, so committee members, I know we had a bunch of questions this morning. Are there questions for Margaret Groban? Yes, Representative Coot.
Thank you. I would jump in. As a former federal prosecutor, we've had some questions about what exactly is going on in the state of Maine with stolen firearms from residences, from FFLs. Can you give us an idea of the status of, is there a problem? What's the scope of the problem? Any kind of data you can provide on that?
Yes, thank you. And I appreciate that question. Appreciate you having me here today. There is data available on crime guns in the state of Maine. Thefts from FFLs, federal firearm licensees, happened 23 times in Maine between the years 2017 and 2021. Unfortunately, that's the last data that I have. I'm trying to get more recent data. And that resulted in 172 guns being stolen from FFLs. So that is something that is happening here. ATF data also shows that around 4,500 guns used in crime were bought in Maine between 2017 and 2021, those same years. And 35% of those guns were recovered in Maine, but 65% of those guns were recovered in other states. As far as criminal activity with regard to FFLs, I think we can all agree that most FFLs follow very safe practices within the state. And that's not surprising. It's a valuable inventory, but there are those that don't. And so there have been one criminal case brought by the U.S. Attorney's Office in 2023 where someone was sentenced to 12 years in prison, resulting from time he spent at J.T. Reed's gun shop in Auburn. He was there for around an hour looking at different weapons. He came back 4 days later, threw a rock through the glass window of J.T. Reed because they had 2 glass plates at the front door of their facility, and he stole 22 firearms from their inventory before he fled the scene. We've had people make straw purchases within the state. A Turner woman in January of 24 admitted buying 55 firearms for other people that were found with gangs in the West Coast. And in January 2025, a Biddeford man was also charged with straw purchasing for gang affiliates outside of the state. So I look at this law as addressing 3 separate problems. One is gun trafficking, which is happening in the state as we speak. Number 2 is suicide prevention, so that training of employees will allow them to look for possible signs of people who might be suicidal. And the third is for employees to know what they can and can't do. Unfortunately, we have seen cases where people go into FFLs and the FFL employee believes that if someone passes a background check, they must sell the gun to that person. And that is not what the law is. They have discretion if they think that person, saying, I don't even know how to shoot the gun, or, I hate my ex-girlfriend, or what a number of triggering things that they can learn from trainings so that they might not go ahead and sell the gun. And unfortunately, we've seen, there have been criminal cases where desperate families call FFLs and say, my family member is getting their Social Security check today. Do not sell a gun to them. They are not in a right mental state. The gun was sold because the employee thought they did not have discretion, and that person went and killed a family member. So unfortunately, we see these things happen. And so I think the training, the prevention of suicide, and the prevention of gun trafficking is all really relevant in terms of this. And one question was asked about requirements. ATF recommends certain safe storage and inventory practices, but those are not the law. And in terms of compliance, Mr. Trahan mentioned that he's inspected every year. He is one of the rare people who is, and I have that ATF data that I can provide. In fiscal year 2024, ATF conducted 9,696 compliance inspections, and that was based on a total of 127,000 FFLs around the country. So that's less than 10%. In Maine, we have 838 FFLs. Of those inspections, 5,000 resulted in no violations. There were reports of violations. There were warning letters, warning conference. License was surrendered by the FFL. That was voluntarily, or revocations in only 195 of those 9,600 inspections. So that gives you an idea of how limited those compliance inspections actually are around the country. And this would allow for the state to be involved. When I worked for the U.S. Attorney's Office, there were many examples of there was overlapping federal and state jurisdiction because the federal government has limited resources. So allowing both ATF and the Department of Public Safety to be involved to ensure that regulations are being followed is always helpful.
Okay, I'm going to interrupt you there and ask that you email the link to the information you were looking at to Eli. Thank you. And I did, Senator Hagan, did you have a question? Okay.
You're fast. That's good, my fast.
Yes, Representative Lee.
You work fast. And I understand you're gonna send us the information. I
Yeah.
just, while it's fresh in my mind, you gave us the information for the federal investigations and the results of those investigations. And
Yeah.
then you said there are 838 FFLs in Maine. Do
Yes.
you have the investigation and result of investigation information for Maine specifically?
You know, I tried to find that,
Okay.
and all I could find was it broken down in the ATF website is by the country. I will try and get that if I can.
Representative Sinclair and then Representative Caruso.
Thank you, Madam Chair. Good afternoon. I appreciate your being here and being able to provide the committee with actual data to help inform the making of policy. We had a couple of questions earlier, I believe from Representative Henderson and Representative Poirier, though I apologize to my committee mates if I'm misattributing. But I think questions were asked by those two representatives with concern for the smaller FFLs about the instance where a state law enforcement agent might go in and in the course of doing such an inspection of records or checking for compliance might witness evidence of criminality. I wonder if you could talk briefly with the committee about the plain view doctrine as an exception to Fourth Amendment jurisprudence.
Okay, thank you very much for that question. I think what might help with that is there was questions about business premises and a concern that if you have a mom and pop selling out of their house, how would you delineate what is the premises or what is not? And ATF has a regulation specifically addressing this issue. And it says business premises, and it's a CFR, a Code of Federal Regulation. I will send that site to Eli. The property on which the manufacturing or importing of firearms or ammunition or the dealing in firearms is or will be conducted is a business premise. A private dwelling, no part of which is open to the public, shall not be recognized as coming within the meaning of the term. So that would eliminate any part of the house that was not open to the public with regard to the dealing in firearms. I think that addresses that question.
Thank you for being here.
Sure.
The initial part of your talk, with all the stats, I was wondering if you could send citations for that so we can review it.
Absolutely.
Verify it. Thank you.
I had one question, but your answer to that also prompted another question. So I understand that it does not inspect their private dwelling, but something that we so what if their bathroom is upstairs, down the hall, past their kitchen? And they let customers use it. Do they have the right to inspect that area?
Well, it defines it as a private dwelling, no part of which is open to the public shall not be recognized as coming within the meaning of the term. So I guess if the bathroom is available, I don't know for sure what the answer would be, but if they allow customers to use the bathroom, then that might be considered part of the
That
premises.
just popped in my head.
Yeah.
But the question that I did have originally, has to do with the Maine State Police testimony, and they were very adamant that they just can't afford to do this. And serving on a committee right now for the Penobscot County jails, I'm very concerned with unfunded mandates and stuff. And so if we pass this, they don't have the people to do this, and they can't get things done, and something goes wrong, the blame is most likely going to fall back on them for not getting out there. But I'm just trying to rationalize like, if we pass this, shouldn't we also have some sort of funding to be able to do it? And it just concerns me. I was rereading this testimony.
Representative, I'm just going to let the sponsor
sorry.
respond because I think she's got the answer to your question.
So I wanted to clarify that the department's testimony relates to the original bill, which has been substantially revised to reduce the workload on DPS. And I have been working with them in connection with preparation of the amendment.
Have they weighed in on the amendment?
We've had ongoing conversations and developing the amendment.
Okay.
And I know the question was directed to you, Margaret Groban. Did you wish to respond as well, or are you all set?
Unfunded mandates, none of it is mandated. The department won't have the ability, to conduct inspections and things. And I think.
But could you turn on your microphone, please, and start your answer again?
Yes, I think that, I don't see anything in the bill that is mandated. Although the dealers have to, in talking about the dealers, they have to do something, but if they're giving examples of what they can do. And as far as the Department of Public Safety, they have to receive the compliance reports. But it's a very different bill than what was originally proposed, and nothing is they don't have to conduct inspections. There are other bills from other states that mandate inspections, that mandate licensing, that increase the burdens both on FFLs and the state law enforcement agency, and this bill does not do that. And I think that there is, I will send this to you, I think there is analysis that most FFLs, if they're investigated at all, it's maybe by ATF every 9 or 10 years. That's how few agents they have doing.
Thank you for sending that information along. We have time for one more question for Margaret Groban, if anyone has one. Thank you for not disappointing me, Representative Caruso. Go ahead.
I know. I'm confused by what you just said. You're saying that this would become law, but the law would be voluntary?
No, I'm saying it doesn't, in terms of the Department of Public Safety. They are not mandated to conduct inspections, but they can conduct inspections. So they are a complement to the existing ATF structure.
And that reminds me, I have a question. In
Go
the
ahead.
definitions for the Department of Public Safety, what exactly does that include?
Is that a question for the sponsor?
Sure.
Do you want to answer it? And in the meantime, thank you, Margaret, for joining us today.
Thank you. I guess I would just clarify that it's the State Department of Public Safety. We had questions, for example, about municipal law enforcement or local law enforcement going into people's homes. That's not anticipated here. This is enforced through the state level Department of Public Safety.
So is that just the state police, not the county sheriffs, not the warden service, not, maybe public safety is ambulance, first responders? What is that?
Representative Lee?
I always go to definition sections because I find them incredibly helpful. Section 948 outlines what of Title V outlines what the Department of Public Safety is. It includes the Bureau of State Police, the Office of the State Fire Marshal, the Maine Criminal Justice Academy, Assistant to the Commissioner of Public Information, the Bureau of State Police, Bureau of Highway Safety, Maine Drug Enforcement Agency. I mean, those are the policy influencing positions within the public safety, Department of Public Safety.
So plenty of for us to think about. Is there any final comment that anybody wishes to make before we entertain a motion to table until next week? Yes, Representative Poirier.
Thank you, Madam Chair. Could we just get either whether they come next time or if there's a written statement from the state police about the amended version? That would be very helpful for me.
Okay. Yeah, I think the sponsor has indicated that she can do that.
Yep, we can ask. I can't, yeah, I'm happy to ask.
Would any committee member wish to make a motion to table? Yes, Representative Sato.
I move to table.
Is there a second? Seconded by Representative Babin. All those in favor? That is unanimous of those present. Thank you, everyone. And so we've we've tabled the work session on 1821. We will let people know when that is being rescheduled for next week. And we are going to we have two things on our agenda. The first is the comparable compensation, and the second is the committee discussion on the forensic examination kit tracking bill. Janet, do you have a recommendation as to which we should take up next. Okay, so there are many people here waiting for the discussion regarding the sexual assault forensic examination kits, and so we're gonna take that up first. So committee members, we're going to begin our work on LD 549. And this is a committee discussion about potential revisions to the bill. And Janet is going to orient us and take us through the details.
Certainly. So you may remember last session, you did a lot of work on sexual assault forensic examination kits, which I'll call safe kits. And there were two bills before you, both of which would establish an inventory, require an inventory of all the kits that are out there and what their status is and where they are. And then also create a tracking system for those kits. And then this bill that we're talking about today, 549, on top of the inventory system and the tracking system, also provided for mandatory testing of certain kits. And the way that worked out was newly completed kits after a specific date would all be mandatorily tested. And there was a divided report in that the majority of the committee drafted the mandatory testing provision one way, the minority drafted it a different way. And so I think that there's some concern that maybe the difference between the two and which one ended up on the table, that might need to be reconsidered based on some more information from the advocates who are behind me. So I just want you to know exactly where everything is. So the front page of this handout is the bill status sheet. So you can see the vote on the bottom left, who voted with the minority versus the majority report. And if you look on the back of this handout, if you ever want to print these, you have to like click all the things before you print, and then everything comes out. If you don't, you don't get all this information. So feel free to ask me, and then I'll feel like I have job security. But if you look down on the back, I've underlined that in the Senate, the minority report was adopted. A little bit below, you can see the House adopted the minority report, and now it's on the table. So when I show you these two amendments, it's a minority report that is currently on the special appropriations table. So the majority, if you look through, just there was a technical change made to the law too. That's on the first page. There's one provision of law requiring these kits to be stored for 20 years. This law still said 8. So this was a cleanup to make it match another provision of law. The next page, page 2, starting on the bottom, you'll see all of the provisions that keep going on about creating this tracking system. So I can go through this if you want. This is not the focus of what the issue is with the advocates, but if you want to talk about it, I'm happy to. But so the tracking system is created and goes on to page 4. I did want to point out, because this has been carried over on the table, some of these dates may need adjusting. So I just circled those in case anybody watching wants to draft an amendment at some point, so they'll know that there's some dates that need adjusting. But this is all about creating that tracking system and getting reports back to the legislature to get information on, like, what have you found out by tracking all these kits? Are they getting tested? How many new ones are there? Where are they being stored? That sort of thing. So all of that's in here. Hopefully this is helping remind you of all these discussions. If we look on the next page, page 5, this is that other statute which already required things to be stored 20 years. It's being reworded a little bit, but that's what you're matching on the first page. And then on page 6 is where there's a difference with the minority report. So if you look at the top, actually, I'm going to talk about the bottom of page 6 just to get it quickly done with. That's the inventory. That's going to be the same with the other report. So what's different between these two is the testing piece. So what both of the majority and the minority reports say is that if there's a kit that's newly completed, so the evidence is taken after January 1st of 2027, then that kit, if you keep reading through it, it must be transferred to a crime laboratory for analysis and testing. So that's a mandatory testing of future kits that are performed as a requirement, whether it's reported only, let me double check, only if the offense has been reported to law enforcement. So if it's a new kit taken after January 1st, 2027, that particular kit involves the victim having reported the offense to law enforcement during the storage of the kit or at the time of the examination. That reported kit or kit involving a reported offense has to be tested. That's the way this is written. This is not what is on the table. If you want to compare it to what is on the table, it's the minority report. So you're going to go to page 6 of the minority report. And you'll see that the minority, which is what eventually both the House and the Senate adopted and put on the appropriations table, has an exception to the mandatory testing. So it's still a new kit after January 1st, 2027. It's still a kit involving a victim who reported the offense at the time the kit was taken or during the storage period. It's mandatory testing with this phrase, unless the victim specifically requests that the kit not be analyzed. So it added this opt-out. There was a lot of discussion before you about whether to have that opt-out, whether not to have that opt-out. The version on the table now has this opportunity to opt out. It's my understanding that that may not be something that the advocates are okay with, and so I'm going to defer to them, but that's just, I wanted to lay the groundwork for what I knew this discussion was going to be about. Does that make sense?
So before we turn to the advocates for a discussion about the opt-out provision, are there any committee member questions for Janet about sort of the baseline knowledge of this legislation? Yes, Representative Henderson.
Thank you, Madam Chair, and thank you, Janet. I think that you're fine with job security, by the way. Don't worry about that at all. So both majority and minority reports track it, test it, and a database for inventory.
So it's like a one-time inventory.
Okay.
That's the unallocated language part. That's why it's unallocated, because it's a one-time inventory.
Okay.
It's a future ongoing tracking system that's created. There are some now you may remember from like either pilot projects or different kind of funding sources, but this is like, now we're going to have a statewide tracking system is what you voted for. So both of them have that. They both have money for the appropriations and allocations for doing the testing and everything else. The only difference is whether this opt-out is done with the testing. You may remember there was that other bill, 1816, that's very similar to both of these, except it doesn't have the testing piece. So the question whether somebody can opt out doesn't arise in that bill because there isn't testing. That's why we're not talking about that.
Okay. And that minority report is the one that passed both the House and Senate and is now on the appropriations table. And really the only markable difference, or perhaps the only difference, is that the victim has the ability to request to opt out of the mandatory testing.
Correct.
Okay, thank you.
Any other questions for Janet? Yes, Senator Hagan.
Thank you very much. So I just trying to remember as I go along here. I'm remembering the whole thing and who testified and did the kits and this and that. So the opt-out, if they opt out, if a person opts out, it's my understanding from way back in the Wayback Machine that if they change their mind at some point down the road, a few years later, that kit can still be tested effectively like it would have been on the spot type of thing?
So I'll talk about what the law says, but the actual reality is what the people behind me know. So the way it works now, without any kind of mandatory testing involved, I have the choice to report it now if I'm getting a kit taken or report later. So I have that choice at any time. I'm the victim. I can make that choice. The way the mandatory testing reads is it's only mandatorily tested if I have reported either initially or I reported it later while it was being stored. Then it would be mandatory testing. The question then is, I've already made this report to someone. Do I then get another chance to say, no, actually, I don't want it tested? So that's the question. And all the ways that works out in the real world are best answered by the advocates behind me.
Representative O'Halloran?
Thinking about this, because I'm a huge supporter of rape testing kits, isn't it kind of like a public safety issue? If you've been raped and your kit can't be tested, that's really only benefiting the rapists. I mean, there's many that they find out later that they have raped 30, 40 women or children, and they don't know, because.
Representative?
So I guess, is it a public safety issue? Should we?
I think that's a policy question. I can't.
Okay. Okay. Who would answer that? Or who could answer?
The other
Okay.
people in the room. Okay. Any other questions for Janet? All right. Janet, thank you very much. So let's get, who would like to first address the committee and answer committee questions about the concern with regard to, for lack of a better word, revoking a request that the kit be tested. Don't know who the appropriate person is to speak to that. Welcome.
Hi.
Thank you for joining us.
Thank you. Can you hear me okay? Hi, I'm Carrie Capaldo. I'm a safe nurse and I oversee the SAFE program at St. Joseph Hospital. And we also are part of the pilot project that underwent for the kit tracking system. And I have been along for the ride for 549 and 1816. So I'd be happy to chat again about any questions you have.
Well, I think I'll just start us off with the big question, which is, can you explain the implementation concerns with regard to including the phrase unless the victim specifically requests that the kit not be analyzed?
Yes, so I think that there's some confusion crossing of what reporting is and testing of a kit. I don't disagree that a survivor should have choice to participate in making a report and changing their mind along the way of participating in the judicial process. That should be for anybody that is participating. But when you're talking, the way the language exists, we're talking specifically about the analysis of the kit. And now we're talking about evidence in a reported crime. And what would be the trickle down of somebody having the ability to withhold that. And then also like, what is the trickle down in the procedure and process if it's already there? So if we have a law that states we're gonna do mandatory testing, when we pass it off to law enforcement, it's already reported. Then law enforcement is to then send it to the crime lab. And so what if it's like in process or, already kind of happening? They also have knowledge of a crime, they have a report, and now they have evidence for that. So I think that, Maine Prosecutors Association could weigh in on that a little bit better about like what that means for evidence. But from a survivor perspective, reporting still remains to be a participant choice, right? And like what level of how they want to participate in the judicial system. So I think that they're all in like the same kind of linear timeline, but there's differences in what those actually mean. And I think that we could potentially create problems
long-term if we allow people to restrict evidence from being analyzed.
Thank you. Let's have some questions from committee members. Yes, Representative Sato?
Thank you, Madam Chair. Thank you for being here. So what I'm hearing is that the way the language is right now with the opt-out is that the reporting part would still continue, even if the survivor decides for the kit not to be tested.
I don't think I understand your question.
Like the
Sorry.
case would continue to move forward, like the cogs of the machine of the survivor reporting to law enforcement continue to move forward. And then with this opt-out language means the case would continue to move forward, even if the survivor decides to have to revoke that consent for the kit to be tested.
I can't speak for the investigating agency and what they would determine, but I think every scenario is different, but that exclusion doesn't stop that. No.
Okay, thank you.
So you're saying that the existing exclusion wouldn't effectively stop that investigation?
I don't believe so the way I read it, but I am probably not the person to answer that question properly.
Okay. Other questions? Yes, Representative Kuhn?
Thank you. I'm sorry. I don't mean to beat a dead horse. I'm trying to understand the distinction you're making. So you're saying that from the survivor's perspective, that whether the kit is tested or not is not the important part of their ability to revoke consent. The important part to them is whether or not to continue in the legal aspects, and that remains in their discretion.
Yeah, so I think before when we were talking about like what's the best trauma-informed approach for survivors and having choice, it's that they always have the ability to choose if they continue to participate in the judicial process. But the language of this is we're talking about a evidence collection kit and not their participation with the rest of the process. I think they're very separate things.
Thank you. That helped me understand it better. I think Representative O'Halloran had her hand up next.
I think I have a better understanding after Representative Kuhn's question, but so with this bill, every single rape kit will be tested and then they can choose whether or not they want to help in prosecution.
So it would be if they've made a report to law enforcement and they had evidence collected, those kits that were already reported to law enforcement would be mandatory testing.
Okay. And so are there people that come in for a rape kit that do not request that law enforcement is not involved in?
Yes.
Okay. Is there a lot of that?
Yes. So they're unreported kits and they just get stored for 20 years, up to 20 years.
And are they identifiable to the victim?
Their name is not on the outside of the kit.
Okay.
I think the next, Representative Pugh, did you have your hand up? No, okay. Representative Caruso?
I lost it.
Okay. Representative Henderson?
Thank you, Madam Chair. And what organization did you say you were?
Sorry, I oversee the SAFE program at St. Joseph Hospital. I'm a forensic nurse.
Thank you.
Any other questions? Okay, so Carrie, thank you very much for answering our questions. And would anybody wish to call up someone else to answer questions? Representative Lee?
I don't know. Well, I mean, I guess I see the bill co-sponsor here. And my question's less about the substantive change and more about where we are right now.
Representative Geiger, could you please join us?
Not like physically where we are. I'm on top of that one.
Thank you for joining us this afternoon.
Thank you, Representative Ellie Geiger. This was my original bill in the previous term. And then Senator Bennett was the lead sponsor this term and I was his lead house. I'm not sure I can answer the question since I only heard yesterday that you were hearing the bill. So
I think then maybe someone else can answer it who's in the room. My question is, I get the policy desire for this change, and I mean, I'm on board for it. I was on the majority report in the first instance anyway. My question is pulling this back, making this change going to help the status of the bill sitting on the appropriations table?
Actually, I would love to provide a brief pre-answer to that, which is that one thing that we could do, this bill is now in the possession of the Appropriations Committee, is that we could send them a letter suggesting that when they take this, if this bill is funded, they take it off the table, they amend it, and that we would include in our letter to them a suggestion that it be amended in a specific way to alter in some way this opt-out provision. And we would change the dates as well, if I recommend. So it's really about our committee making a recommendation to the Appropriations Committee.
I think I know the answer to this because I looked at both of the fiscal notes for the majority and minority. They're identical. It doesn't change the cost of the bill.
Right, but we don't, if there's concerns about implementability, that's the thing. And I'll just turn it over to the sponsor.
Thank you so much. So just to, because it's been a while, sort of set the context for everyone. We have thousands of sexual assaults a year. We have a few hundred kits that are requested. We have no idea where they go or what happens to them afterwards. About 80 go back a year for testing. We have a conviction rate of less than 1%. And what other states have found, and again, I will remind you, Maine is the only state left in the nation who has failed to start this process of tracking, following, inventory, and then testing. What other states have found is that if you test, you discover whether the person wants to proceed with prosecution or not. When you test every kit that goes back to the crime lab, what you discover is there are very few sexual predators responsible for a very large number of rapes. In Maine, we have no idea. We are not finding that. We don't have any way to find that. And so in Maine, essentially, rape is free. Sexual predators are completely without consequence. So this is a process where we have to begin to inventory, track, and then test. And once someone has filed a report, I mean, we're not testing all the others where someone isn't filing a report, but once we have filed a report, we are reporting a crime. And as in any other crime, it's important to look at the evidence that you have available.
Thank you. Did you have a follow-up?
I just want to clarify that I'm 100% in favor of this bill. Hope it moves off the appropriations table. I was hoping for a magical answer that this would like all of a sudden make it come off of the appropriations table.
Representative Caruso?
Thank you. Thank you for that. Thank you for the refresher. I'm also 100% behind this. I was wondering if we could ask the Prosecutors Association to come and weigh in on this.
Yes, let's see if there are any more questions for Representative Geiger. Any questions for Representative Geiger?
Thank
Seeing
you so
none,
much for
thank
allowing
you.
me to speak.
We appreciate you being with us. We hear from Shira Burns on behalf of the Maine Prosecutors Association. And Representative Caruso, I'm going to turn to you to ask a specific question.
Shira Burns, Maine Prosecutors Association.
Hi.
Hello.
Thanks for being here. With regards to the majority or the minority report, is there a preference to you in which it would be most helpful to you for in the process that you go through with convictions and all of that?
Yes, we are supportive of the majority report. The minority report has many concerns that we've stated before, that also when we come to these kind of bills, and I'll say, I mean, I know that the terms are victim-centered, trauma-informed. We truly want that. And I think this was an attempt to do that. And I respect that in every way, but we have to sit down with the people that do these cases from prosecution, from law enforcement, from the crime lab, who may be getting a call from a victim saying, I don't want this kit analyzed anymore, from Mikasa, from from our safe nurse, and how does this practically work? And we don't think it does work. And that's why truly all these organizations cannot support this language. I know there was a letter that was circulated on behalf of the Safe Board Advisory Board, which I believe is based at a statute, which has many organizations. I do have a copy of the letter where they're asking appropriations, please fund one of these bills. We need it funded, but they put an asterisk saying, except you can't fund, don't do this bill if you don't take out the minority report because of the problems it can cause. I can talk about them. I'll say one of the big things that I haven't heard discussed. I mean, Carrie is literally statewide known. She is an amazing safe nurse. Every day I'm thankful for what she does and the job she does and the things she sees. So well respected, and we've had so many conversations about this, is about minors. They do pediatric safe kits, and the verbiage used here is the victims. And unfortunately, a lot of children are perpetrated by their caregivers. We think about stranger danger, and that's not actually what we see. We're usually assaulted, perpetrated by the ones that say, I love you. And so what's really important is these are just, again, one of the things that we discussed, is that if it's the caregiver, who makes the choice? So having this a minor make a choice. And again, the wording is unless the victim specifically requests that the kit not be analyzed. Our conversations, we've all agreed, no victim says that. No victim talks about their kit being analyzed. What the conversation always is do you want to report to law enforcement? That is a choice they have. We've all stand by that. And we do have a lot of what's called anonymous. And I love Carrie's verbiage. It's unreported because I don't want to say anonymity, because actually in Carrie's position, they're mandated reporters. So if this child is being sexually assaulted, depending on who the perpetrator is, they actually have to report it anyway to DHHS or the DA's office. And then let's say that child says, for some reason, I don't want this kit analyzed. Again, verbiage that the victims just wouldn't even think to use. No, it's all the conversations are around, do you want law enforcement involvement? And that's a yes, that's a no, that's a maybe sometimes. Let's go through, let's take some time. And that's what we've heard about delayed disclosures is 30 years down the road. Like we know that. And I'd love to continue to work with stakeholders to keep developing off that practice on continuing to be trauma-informed and victim-centered. The criminal justice system isn't. I think I've made that very clear. It's not a great process. And why do victims not want to be part of it? Because it's not a great process for them. But this is not like an opt-out. This is just having their test not analyzed. A lot of the sexual assaults we see, it's not about who did it. Was it consensual? Both parties are going to agree there was some kind of sexual contact, whatever it was, and it's just, was it consensual or not? And those are the kits in the past we haven't been testing because, again, what our old thought was, why would you need that for prosecution? He said he had sex with her. So there's, it's going to be his DNA. The question just is consent. So anyway, I do have the letter. If you want to see it again, it's just all about the supporting of it. But there is a big asterisk from many different organizations saying, please take out this minority language.
Representative Pugh.
Thank you, Madam Chair, and thank you, Director Burns. I just want to make sure that I'm understanding sort of the evidentiary landscape here. So in a scenario right now where there is an opt-out, for instance, say a victim wants to go forward with the prosecution, and that means that the test is then, the kit is then tested. Then say that victim decides to no longer go forward with prosecution, but that kit has been tested, so there's the forensic evidence. Say then there's a different victim in the future who does want to pursue criminal proceedings here, has their kit tested. In the course of that, if both kits are a match for the same perpetrator, is that original kit that didn't result in prosecution, is that evidence available to the prosecution in the second case of the second victim? Could you just sort of explain if that's permissible or how that might work in that scenario?
I will say there's so many ifs in like this fact pattern of what happened. Let's say we find out, there was a sexual assault kit. They didn't report, they did. We didn't pursue prosecution. And again, we still can prove, even if a victim does not want the kit analyzed, prosecution still can be pursued. We have to just figure out, do we have a case in chief? Can we present evidence if the victim is not going to testify? And that's because of the confrontation clause, hearsay. There's just many evidentiary issues. So let's say that prosecution doesn't go forward. There's a report of another sexual assault, and then we find out the DNA matches. Well, that could be, if we're talking about cases that are whodunit, then we may reach out to that first victim to see if hey, there's something else, and we could bring the charges together. But if we still don't have a case in chief, like there's still not evidence, because maybe that victim's passed away, gone, not willing to participate, and I don't want to say not willing to, but because the collateral consequences is not going to participate, we're not going to be subpoenaing this victim to drag them in to come. We may not still do that first one. But it would be a conversation, and that sometimes we would maybe indict on both if we did have evidence of both cases that we could use and present, knowing that there's going to be hearsay and confrontation clause issues.
Representative Henderson and then O'Halloran.
Thank you, Madam Chair. And I will also state I'm 100% behind this bill. And given that I was on the majority report, I hadn't given much thought to the nuance of the minority report. But now that this is on the table, I think it's good discussion. In your opinion, do you believe that this could create any form of a credible argument for the defense that the alleged victim or the victim or alleged victim wasn't given the opportunity to opt out of having this tested?
I think in my opinion, if this language remained in, unless the victim specifically requests that the kit not be analyzed, and we proceed with prosecution, which we can and do sometimes, this victim, first of all, I think it's going to be a big problem. This is one of the things, I don't know how this will play out in court. If a defense attorney, their client saying, I'm not the one who again, this is a question, is it about consent or is it about who did it? I don't know what case. If it's a who did it case and defense is their client is telling the defense attorney, it was not me. I did not. There was, it won't be my DNA. I didn't. Defense is going to push really hard to get this kit analyzed. It's evidence in the custody of the state of Maine that's not being analyzed. I can imagine they wouldn't be asking for a court order to say, Your Honor, forget the statute. We have this is evidence that the state has custody of. This is a Brady violation. Give us the evidence. And so that whole court procedure of evidence in the state's custody that we're not testing, I think is going to be a humongous deal in court. Now, let's say for some reason, maybe the defense defendant is not telling their attorney, don't test, I don't want to know, you don't want that kit tested. You're right. Don't test it because what the evidence could show. But could the defense attorney then cross-examine the victim on a choice that the kit not be analyzed? And it does look like their credibility. And then we're talking about experts about, well, why, in these situations when you're going through an 8-hour safe kit and all these things are being done to you and you're trying to make these choices, what was going on? And then we'll have to bring in Carly as an expert and talk about choices and the trauma that affects the brain and decisions that are made then. And I don't think we should have victims being cross-examined about this specific thing. So.
Thank you.
I'm going to, Representative O'Halloran, I'm just going to defer to Representative Sinclair and then also seek out comment from Representative Sato because they were the two who are in the committee room now who were on the minority of the report. The rest of us were on the majority report. Representative Sinclair and then Representative Sato.
Thank you, Madam Chair. Good afternoon. Chair.
Hello.
So I understand everything you're saying, but don't you also see that there's a possibility that if we force the victim to have the kit tested and the test comes back inconclusive, that opens the door to the defense to have a number of tests done on an alternate suspect theory? And couldn't that expose that exact same victim that we all want to protect? Remember, it was a unanimous committee recommendation that the bill passed, just slightly different forms of it. Wouldn't that expose that same victim to potential exposure of their sexual behaviors?
Well, I'll say anything that's tested that's inconclusive, that happens now. For any kit that is tested, that could happen. Also, we do have the rape shield law, so you can't bring in court their prior like sexuals, except of course, if it's playing into that, like they were having sex with somebody else right before, of course. But this doesn't change that. And that's not that what's currently happening too, is that could be inconclusive. So I don't see this strengthening that. Again, I think it goes back to the original reported or unreported. There is a lot of victims that don't want this reported, and that is the option. But we are talking about here like a very specifically request that the kit not be analyzed. And I find that totally different.
So are you saying that the decision to report is in effect a request for it to be analyzed? Or is that not what you're saying?
Yes,
A little confused.
well, it's not right now. It would be if this bill, not if the other bill passed, but if this bill was passed. Right now, when it is reported, it does go to the crime lab, and then there usually is a discussion. And again, as I said in the past, we haven't been testing every kit because most cases are about was it consensual or not. If there was any kind of who did it, we didn't, I was sexually assaulted, I don't know who the person is. Those were being tested. But the unreported kits, and those are long conversations that a victim does have with the safe. They also call somebody from ICASA, or not ICASA, sorry, one of their sister agencies to talk about these different options they have. So I guess it's just like the nuances of each one, but what we don't want to do is give a victim this like false hope, saying that if the victim specifically requests that the kit not be analyzed, that just means everyone's quiet and we don't do anything like an unreported kit. It will not be treated like an unreported kit whatsoever. It will still go to law enforcement. They already are investigating it. There may be witnesses that are, let's say it happened at a party, that are interviewed. So this is like very much to me a false hope when victims do want to suddenly say, hold on, this process is moving so fast. But that is what I want to continue to talk to stakeholders on. What is a good way to address that? We see this all the time in these crime types, domestic violence, very much so. But what we've all talked about as stakeholders in domestic violence, and we know that sexual assault is very prevalent in domestic violence cases, is we have to be careful of the defendant's undue influence. And that happens in these crime types very specifically. And we don't want to give them the power at all to request it not to be tested. And that doesn't have to just be them saying, I don't want it to be tested, but I love you again. And you've heard me say this. That was one of the very specific reasons a lot of people talked about this specific language not being the right language in a trauma-informed, victim-centered manner, because being trauma-informed, victim-centered is realizing the power and control dynamics that happen in these relationships.
Thank you. I want to turn to Representative Sato, and then I'm going to go back to Representative Sinclair because they again are the minority report. Go ahead, Representative.
Thank you, Madam Chair. I think you and also Carrie have said this throughout but I just want to be very clear because the scenario that I'm coming to that is worrying me with the current language in the minority report is the situation where, because again, I also want to be clear, we're only talking about reported kits. I feel like that's really clear. They're only talking about reported kits. That's it. And so in a case where this an alleged victim has reported and then has gone through the SAFE process, which means that law enforcement is going through the investigation process, and then under this bill would then require the testing of that kit later on in that process or sometime between then. And in this case, the alleged victim has been assaulted by someone they know, someone who they live with, like a loved one, which does happen. That person can either coerce or use any undue influence on that person to basically push them to ask that kid not be tested, and then say so that the victim then follows through, right? Gets scared, decides to revoke the consent to have the kit tested, but the case is still going. And so there's a scenario in which the case goes to court, goes to trial, and this evidence doesn't exist. And it puts the survivor in a position where they are, where their case is much less strong because the perpetrator has, because of that power dynamic you were just talking about, has exerted undue influence on the person. Is that what, because that's the scenario that I'm wondering. And so this language here, that would allow for that.
Correct. Yes, that is one of the concerns that was spoken a lot about the stakeholders, exactly what you're saying.
Okay, thank you.
And then Representative Sinclair, did you have a follow-up?
Just a quick one. Thank you, Madam Chair. So I heard you saying that the prosecutors organization dislikes this language because of the possibility that it would enable a defendant to end up making the choice rather than the victim. But is there alternate language that you could perhaps help the sponsors work on that would let the victim be making the choice rather than the state or the prosecutors association making that choice for them?
So I really appreciate that question, because we are, again, talking about victim centered and trauma informed. And that's what we keep saying is like this bigger conversation, because the first choice they're allowed is the reported, unreported. And that really is where the power lies. And I think what a lot of the conversations we have is when we're talking about a reported kit where there's now evidence of a reported crime in the state's custody, is there room there to give survivors more choice? And that's been a big discussion, I will say, we've had on the domestic violence side for a long time. And what we keep hearing is, as much as we want to be victim led, those power dynamics are so strong that we are told the best practices is to continue prosecution even when a victim survivor says, I don't want this to go forward because of these power dynamics. And that discussion has started in the sexual assault realm. Again, they cross paths all the time. The short answer is we're happy to continue to have those conversations. It's a little more difficult because we're talking about evidence of a crime in the state's custody. And so we want to talk with law enforcement, the crime lab. What happens when they open up the kit, once you open up like the Q-tip, let's say that depending on timing, if the victim calls, who's telling them, well, this actually kit may not be able to use it anymore. So are you sure in this moment? But absolutely happy to continue those conversations to make this process as trauma-informed, victim-centered as possible. We don't have language today, and that's something we've talked about a lot, is it was such a can of worms that there was nobody, even the Safe Advisory Board, they're like, we just have to say no to this language, but let's keep talking.
I think, Representative Kuhn, I think you're okay. Other Representative Halloran, did you have your hand up too?
I didn't see it, but that's good.
Other questions, committee members? Yes, go ahead. Shira, thank you.
Thank you, Madam Chair. I guess my question now procedurally, because this is not a work session, the bill's not in our possession, to send a letter to AFA, does that require like a motion? Is that a vote? Like what is the next? I'm not saying that I'm going to do one or the other. I'm just curious what to do, what's going on.
Yeah, I think we would discuss whether we wanted to do that. And then we can't really vote on the bill because it's not in our possession, but we could all agree that the committee would send a bill to the Appropriations Committee, making the date changes and then taking out that specific phrase. Janet, they have an updated version of what I just said.
So my suggestion would be, because it was a divided report, if there's a chance you would all agree, maybe vote on, it's not like an official vote that gets reported through the system. It's my vote, like we do with a budget bill, vote on whether you support the letter supporting the change to the language. And then maybe, since some of the people aren't here, giving them time to vote so that you can find out if you have a unanimous support from the committee as a request to AFA to change the language because you've investigated the issue more. I've written down a lot of the reasons the advocates gave so that if that is the direction you want to go, I would try and put those reasons in. You would have a chance to look at the letter. That might be a chance if maybe the other people aren't here. So you could try and see, because it is divided. I think it would be weird to then have a divided letter, but it's entirely up to you. And then also, I did point out the date changes because I didn't want anybody to think in reference to your question before, you could just ask them to back it up and just take the other report, because I don't think you can. Since other amendments have to be made anyway, I think it's more efficient to do it at AFA. And if you want, I could even draft the language so that it's ready for them, because as you know, the table happens really quickly at the end and it could be lined up for them, which makes more sense if it's a unanimous committee recommendation. Does that make sense?
Yep, so there would be an unanimous committee recommendation describing what we think the change should be, and then a draft from you of the amendment language. And so how do people feel about going in that direction? I'm going to ask Representative Sinclair and Sato, if you want a couple of minutes to think, we can take a little bit of time. Yes, Representative Sato.
Thank you. I think having a couple minutes to think would be helpful, especially because there's a third member of our committee who also voted in favor of the minority report who's not present for this discussion. And so I think it's important for so that to be able to think, and so that also to give the senator an opportunity to decide.
Do we feel like it would be helpful to ask Janet to draft the letter and the amendment language? And then when we take this up again for committee discussion, we would actually have that available. And maybe that would also help Senator Talbot Ross, who wasn't able to be with us this afternoon. She'll have a review of what the conversation was. Yes, Senator Hagan.
Sorry, I had to step out. I don't know what's going on.
Okay.
Sorry.
That's okay. We're discussing the possibility of sending a letter to the Appropriations Committee suggesting amendments to this LD should it come off the table. Yeah. Representative Sinclair?
Thank you, Madam Chair. If we were to follow the process that I understand you to have just outlined, what I would suggest is that when it comes back for review, we have not just the one that would implement the change that would switch us from the minority report to the majority report, but also a version that would only make the date changes so that we as a committee could discuss both of them and figure out whether we wanted to ask AFA just to fix the dates or instead to go back and essentially go against what the Senate has already approved. If I'm being clear. If I'm not, I can try other words.
No, I think the Senate approved the minority report. Exactly. Yeah. Okay. Both
chambers.
Both chambers. Right. Yeah, I mean, yes, we could have both of those documents. They would. Yeah, is that, Janet, is that doable? Thank you. Representative Henderson.
Thank you, Madam Chair. That's actually a perfect segue into my next thought, at least to share with the committee. Everyone knows I'm 100% for the majority report, voted in favor of it in the House. That, and even after today's discussion, I think I'm more convinced that this is the way we should go. However, I guess from an ethical perspective, the minority report did pass the House and the Senate. So the majority of legislators already voted on this other language. And I guess my question would be, maybe not ethically, but maybe ethically, where does that stand? Us asking AFA to change what the House and the Senate had already, the majority of them have already agreed upon.
So it would go back to both chambers for votes. If the Appropriations Committee put an amendment on it and changed the language, then it has to go back through the process. Representative Kuhn, did you have a?
I'm just thinking about the two different reports and whether we should just have more conversation and try to resolve where we are before we draft two different letters. I don't know, because part of me hears you saying, Representative, that for you, the most victim-centered approach is just not to have mandatory testing. So really your minority report might have been a not to pass. Is that not what am I not hearing that correctly?
100% no.
Okay, good.
I want victims to be able to have their kits tested. I want the database to be created. I want it to be the policy of the state that going forward, all of them will be tested, except I would like the victim to have more of a voice than just their initial decision whether to go and talk to a cop or not.
Yes, Representative Lee.
Now reluctant to say this, seeing Senator Rotundo enter the room. No, it's fine. Understanding that our letter would solely be persuasive authority, I'd be very reluctant to send a letter unless that letter is an expression of the unanimous sentiment of this committee.
I agree with that. Okay, so let's have Janet draft one letter, knowing that we can change it. And have another committee discussion of this. Once we have the language to look at. So is that acceptable to everyone? Would anybody strongly prefer to have two letters, in which case that we, in this modern age of word processing and with Janet's excellent skills, it would be easy to do that, I'm assuming.
I wasn't understanding to write two letters. I was just understanding to write two draft amendments.
Yes.
One making the change and one not.
Okay, yes.
I don't mind doing that. I don't know what I would put in the other letter. One letter
That's right.
is, we had a change of heart about this, and the other one is just the dates are wrong, which they probably would figure out on their own.
Okay, good point. Thank you for that. Yeah, okay. Is everybody comfortable with that? Two amendments, one letter. We will have another committee discussion next week. Okay. Senator Hagan?
I'm gonna take a chance here and risk something. I'm just having a hard time remembering. But I'm looking at the roll call votes in the House and Senate on that bill when it happened. There were none. There was one vote to suspend the rules and it failed. So what am I forgetting? How did that go
No.
through? I just can't remember.
Yeah, I think, well, Janet, do you want to take that
So
up?
if you look on the back of the first page, it tells you all the actions in either body. This is my job security of how I could print it. I don't see a roll call listed, but somebody else might, and if it was, it will be listed here somewhere.
Yeah, and yes, and I think this concern about that phrase was emerging as the bill was leaving committee and going to the chambers. So it was kind of a new concern on the day that the committee voted, and it was toward the end of session. And so we didn't have time to keep it in committee and continue to address it until we reached an end point that we all agreed to. Yeah, sure. Representative Sinclair?
I will happily watch the video if necessary, but I'm wondering if any of the senators who were present when the Senate voted on the bill can comment on how the Senate came to adopt the minority report rather than the majority. And if that's an unfair question, I apologize and withdraw it.
It's not an unfair question. So I believe I was the person who moved to accept the minority report in the Senate. And I believe it was because this issue was still in my mind unclear. And I'm not remembering whether the sponsor or other advocates had requested one way or another, or whether my colleagues were much more interested in the minority report. I don't remember. I do remember that it was kind of still an unclear issue at that time. Any other discussion before we move on to our next work session? All right, thank you, everybody, for digging into that. We will get to the right place on it, wherever that is. Thank you. Okay, so we'll end our discussion and then we'll change gears and take up our work session on LD 374. And this is an act to provide, so opening the work session on 374, an act to provide comparable compensation and benefits for deputy and assistant district attorneys, assistant attorneys general, and public defenders. And Janet, can you orient us, please? Yes.
I know we're running a few minutes behind, but would it be possible to take maybe a 4-minute break?
Yes, we could even do, we can take, let's do this. Let's come back at 10 minutes before 3. That will give us all a little opportunity to stretch. Welcome back, everyone. We are going to take up our last work session of the day, I believe. And this is a work session on LD 374, an act to provide comparable compensation and benefits for deputy and assistant district attorneys, assistant attorneys general, and public defenders. And Janet, can you orient us, please?
Certainly, I'm just going to read the little summary from the bill analysis just to remind you about this bill. So under current law, each elected district attorney has the authority to fix the compensation of deputy district attorneys and assistant district attorneys in their prosecutorial district, quote, subject to the approval of the attorney general and the governor, end quote. And the law further directs, quote, for purposes of compensation and benefits, that the deputy DAs and ADAs must be, quote, treated comparably, end quote, to assistant attorneys general. So that's the current law. The bill would amend that statute to provide also that for the purposes of compensation and benefits, deputy DAs and ADAs must also be quote, treated comparably to a new category, not just AAGs, but also public defenders. And then the bill adopts a definition of public defender to include attorneys appointed by the commission. So it wouldn't be that they would have to have comparable salary to someone who's a contract counsel or assigned counsel and gets an hourly reimbursement. These are the employed attorneys for the commission. And you then, without going through everything else, but just to remind you what you had in your packet, you had asked a long series of questions to get at sort of what are the precise benefit packages offered in these different scenarios? What are the different salary ranges? Where is the difference? Also, are there any caseload standards that are applied? What are the current caseloads? And so all the information I received in response was compiled in the attached chart, which goes through each of those categories of questions you asked and compares for public defenders. And these are, again, the employed public defenders versus ADAs for prosecutorial offices, and then also comparing district attorneys to district defenders, which is the somewhat equivalent status. So then at that point, I think folks thought there was a lot more. You got a lot of the information you asked for. You didn't get all of the information you asked for. There were questions about how comparable are the two jobs? How do we figure all that out? And that's when you decided to carry it over to maybe think about it more and see if there was more information you could get. That's the last that I remember.
Thank you. And so committee members, I'm just going to share my perspective on this legislation. And I just want to thank the sponsor, Senator Peggy Rotundo, who's here in the room with us. And this is her legislation. We did ask for a lot of information, and we still had more information we wanted access to in order to address the underlying policy question, which is really how do you fairly compensate everyone who is in this system, particularly because it's a system that's changed from having independent counsel who are retained by MCILS to having public defenders' offices with people who are employees of the state. And so my suggestion would be that we embrace the opportunity to try to figure this out, but we do it by creating a study commission that we would all strongly support, that would look at what are the work burdens, what are the compensation arrangements, what are the benefits that are available, what are the other types of benefits that are available, like loan forgiveness, and really try to look comprehensively, because in a lot of ways we are entering a whole new era with our new public defender system, and it does give us an opportunity to gather good information and then make recommendations based on what a study committee or commission would do. So I'm just going to put that out there. I did talk to the sponsor about it. She thought it was okay. And Senator Rotundo, would you like to address the committee, or are you okay? Thank you. Thank you for joining us this afternoon.
Thank you for allowing me to speak. Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee. I think a study committee would be an excellent way to proceed. There were a lot of questions that you raised, excellent questions. I know we're interested in parity, so that one side doesn't lose people to the other side. We need both prosecutors and we need public defenders. So I would really welcome a study to see what you find out, and to see if there currently is parity, and if not, whether or not you want to do something about that. So thank you very much.
Thank you. Are there any questions for Senator Rotundo? No. Thank you very much. Let's see. I think I will do something kind of unusual and ask those, we have many people who are important stakeholders in this legislation in the audience, and I would just invite you to step forward and share your thoughts about this suggestion. It would be really helpful to hear from all of you as to whether you think that this is a good idea. And this is a very earnest effort to understand where we're lacking in parity and how to get there. It's not just a study. Yes, Representative Sinclair.
Madam Chair, I'm sorry, it was unclear to me whether you were looking for committee members to make specific invitations. If so, I'd love to invite Freya Tarpinian, the head of PDS, to come up. I know she has some interesting perspectives on the different axes of potential parity that the committee or the commission ought be investigating.
Thank you. And could you please join us?
Good afternoon. I think in principle, I don't know.
Could you
how
just
it-
introduce yourself for the
yes.
record? Thank you.
My name is Freya Tarpinian. I'm the Executive Director of the Maine Commission on Public Defense Services. Thank you for the invite. Ms. Claire. I think a study is a great idea. I don't know how anybody could be against equity and parity for equally situated people doing similar work in the same system. So I think that's a fantastic suggestion. I think as part of that study, reviewing the comparative benefits of the comprehensive compensation packages would be important. There's a lot of details. At the end of the day, it's not going to be a straight apples to apples comparison. But I'm not going to get into that. I think that's what the study would be for. I think something else that should be investigated is what it would require to make these positions truly parity. There's a way to give parity very quickly, which is we are, as public defenders, not me anymore, but when I was a public defender before you last year, and all the people that are employed by the public defenders are currently governed by a collective bargaining agreement because they're members of a union. That union requires, that agreement requires when we hire that we bring people in at a step that is equitable to other people who are similarly situated. So we take comparative years of service, we line it up to where people are being paid at the moment, and then they get paid the same based on the impact study done by the HR. And so that's a process that ensures everybody in our agency, it doesn't matter if you're a better negotiator or worse negotiator. What it matters is the years of service that would qualify you for the position. And it is the best way that we know to ensure parity within our own system. And I would invite or suggest respectfully if the study could include what it would require to give that opportunity to folks. Obviously, you can't force them, and I would not want to force the district attorneys and their staff in anything they don't want to do. But I think there's a lot of legal questions about how that might happen. And so I think if the study could just touch on that to give information, whatever. There's a lot of steps between here and there, but I don't think it's a well understood process. It's a highly unusual to have a large group of people in state service that are not allowed, that are prohibited by statute from collective bargaining. And so if they wanted to ensure parity, that would be one of the ways that could be accomplished if this body chose to do something, and if they themselves chose to. Again, I don't believe in forcing people to do anything, but I think that if we knew what the path looked like, that might be an important part of the study that would give people information. I know when I was working for the district attorneys, there was a lot of discussions. There was a lot of fear and anxiety based on the lack of job security when a new administration comes in. And I don't know of any other way to give protection to frontline employees. So, you know, my name was personally bandied about in the press when an individual challenged the DA that I worked for and said, I'm going to fire her. And I know that that was hard to go to work sometimes to think about that and to like appear in court with that attorney and address a court and know that your name is being discussed publicly and personally and you're being attacked because they did not like what you were doing. So I would just say as a personal note, that might be a consideration.
Thank you. Any questions, committee members? Yes, Representative Lee?
Did the state recently do a compensation study? Am I conjuring that out of nowhere? Okay.
Yes.
Yeah,
I think it was 2021, 2022, it came out. There is statistics and it did review all the district attorney positions were included. None of the public defenders existed at the time. Yeah. I don't know how it would affect it, and there's discussions ongoing about redoing that study, which I don't know. I don't follow closely. I'm just aware.
Thank you. That was a great question.
I was thinking about, I mean, just sort of batting back and forth in my head, whether a compensation study is a more appropriate mechanism or if use of those compensation studies would be a useful thing for a study commission to look at.
Yeah, and I'd like to ask the commission to consider some of the policy issues as well as collecting the information. Just because it would be helpful to know what the options are. Other questions or?
Can I
Rayla,
make
did you-
one more point?
Yes.
Thank you. There was a lot of discussion during the last public hearing, and a little bit here about caseloads. I would resist that because, first of all, the job of an ADA and a job of an AD is very fundamentally different. I will not go into the minutia right now of what it is, but having lived that life again, I worked for the district attorney for 10 years. And I was in administration at the end of that. And I worked as a public defender in the state for a very short time, I feel like a couple of years. But as long as there were public defenders in the state, pretty much. So there's job responsibility differences. There's also a tremendous variety in caseload numbers depending on subject matter. So I would not anticipate somebody handling manslaughter, murder cases would have a similar caseload of someone having. So there's a tremendous variety when you get into specifics on cases. I think there should be a discussion about making sure people are doing the work. That's not what this is about. But there's a lot of detail and really complicated information. And I know from when I was an ADA or a deputy DA, really, the caseload variation amongst districts is very enormous. And there are no standards currently for prosecutors. That is fully in the discretion of the elected DA. And so when we're talking about caseloads, I just asked for parity for that sort of discretion too.
Thank you. Anything else, committee members, for very letter opinion? Seeing none, thank you.
Thanks.
Any committee member wish to ask a question of someone else in the committee room? Yes, Representative Henderson.
Thank you, Madam Chair. This might be getting the cart in front of the horse, but if someone from the Prosecutors Association wouldn't mind coming up, I'll wait till you get here. Next question. Anyone here from the Prosecutors Association? Anyone at all that we might know of?
Shire Burns Maine Prosecutors Association.
Yes.
Long time no see.
Thank you for rejoining us.
So to kind of put you on the spot, having heard the very brief discussion we've had thus far, would you have suggested members, like who you think, obviously somebody from a representative from one of the DA's office, any other stakeholders that you feel as though would be pertinent to this type of discussion?
So I'm going to interrupt for 1 minute and just ask Representative Henderson if you could include in your question, what do you think of the idea of having a study?
Sure.
Thank you. I appreciate you doing that favor for me.
It just came to me that I should probably ask you what you think of us doing a study in general.
Representative Henderson, thank you so much for asking me that question. I want to thank Senator Rotundo for being the sponsor on this. Her relationship with District Attorney Neil McLean, who's District 3, is really solid. They hear each other out. She listens to what he has to say about public safety of District 3. And this bill came out of that conversation because he's like, we are down this many prosecutors. Trying to keep up with any kind of caseload is just impossible. And there was a series of conversations she had with her stakeholders in her community. She listened to them and she brought practical bills in response. And we are so thankful for her dedication and looking at the big picture for everybody involved. We had a discussion, I had a discussion with Neil regarding this being a study. We have no problem with this. I did hear what you said, Senator Carney, about the study, and I heard with what the director just said, and I'm going to really align with Freyla on this. Is she talking like about I think you might have brought up like caseloads and what we do, and what I heard, and I hope I'm not misquoting, is like we're kind of doing different things. I think we all agree, and I'll say this because before this bill came about, we did have a sit-down conversation with who at the time Director Billings, saying we believe we should be paid the same as you. They were very supportive of that. They testified at the public hearing in support of the bill. I would back away from caseload, workload. I think we would all agree is we're in the criminal justice system, they're defendants, we're prosecutions, we're all working really hard in this very overworked situation, and we all probably deserve a lot more money than any of us are getting, and so probably like even the compensation is probably going to say we deserve way more. That's not where we're going at. The point of this bill specifically was there is a concern based on the salaries given is that prosecutors are being paid less, and that is could be one of the possible reasons of why we have many openings that are going unfilled. So I'd ask this if we're looking at the point of this specific bill and anything that to do with this, it would be about what is the compensation packages of prosecutors and public defenders. We're not talking about the appointed counselor for the hourly wage. That's not comparable. And can we mirror those? Because I think we all agree that we do deserve the same here. When I'm looking at who that it would be HR of the AG's office, who oversees the budget, who oversees all prosecutors in the state, and HR of the other executive branch employees who who PDS falls under, would be my suggestion. I will say we did do a lot of work off session with them. I worked a lot with HR at the AG's office. I did make my own chart. I can give it to you, but again, I don't want to, if you want to do an official study to show it, but we did look at, we're not unionized. We're at will employees. They are part of a collective bargaining unit. Sick time caps, vacation caps, longevity pay. I mean, all of that stuff we asked, and they were able to give me everything. And the AG's office worked with I think it's BHR, is that to get everything for them so we could look at the differences. So I actually think it'd be pretty easy if we're staying out of caseloads, which what I heard is they agree with that, and I would totally agree with that.
Yes, thank you very much, Representative Lee.
I don't want to creep the mission too much, but would it also make sense, given what you've said and what we all know to be very true, is we're having a hard time recruiting both prosecutors and criminal defense attorneys in the state of Maine, if we also have the study look at what successful recruitment would include, including compensation? Or is that too broad?
Is that a question?
It's a question.
Did you say this question for me? I guess I don't know if they're having a hard time. I really don't know if they have positions that they're having a hard time filling or not. In PDS, we're having, I believe, a hard time with getting counsel that they pay, but I really don't know if they are having that hard time. The only thing and again, I don't know what the cost is with this. I don't want to keep elevating the cost when the point of this bill was very specific of we see we can see the salary differences. I don't think you can just literally look at the piece of paper, look at the dates on them and see. I mean, I know a lot of us went to law school with people, so we can say, oh, look how much they make, look how much I made. We both graduated the same date, that kind of thing. But obviously, you have to look at the whole compensation package. I totally agree with that. So I guess I would like to keep this narrowly focused only for the point. And if there wasn't more to a cost to it, go ahead, or I say, yes, we both love to be paid more. I just don't know if that elevates cost.
Yes, Representative O'Halloran.
My question's actually for Representative Lee. So when you say that, that kind of makes me think like a lot of towns did like hiring bonuses of like $20,000 to law enforcement, things like that. Are you suggesting that they look into things like that as far as attracting and obtaining people?
I mean, that would potentially be something that would come up in increasing the compensation packages. I think that kind of thing might organically come up though when we're looking at parity anyway. So I was thinking even more expansively of whether or not there's other impediments to recruitment. But I'm also respectful of the fact that they don't want to overly expand the scope of the study committee.
Janet, did you have an observation?
Yes, I just wanted to, because you talked about cost of a study, I think you need to decide who you want to do this study. So if it's a legislative study and those are budgeted at 4 meetings and the cost is the same no matter what the duties you put on it, it's just, can they get it all done? And if you give them too many duties, they're going to themselves have to narrow it down because they need to get it done in 4 meetings. You can ask that there be 6 meetings or whatever, that would increase the cost. You could also, as a different alternative, direct certain people to do the study, certain agencies to work together, for example, to do the study that may or may not have a fiscal note that might be impacted by precisely what duties you put on it. Sometimes those agency studies, they say, well, we can do that in our resources. But if you ask them for sort of the sky, they're going to have to be honest and say, we can't do that without more money.
Thank you. My initial thought is that we stick with a legislative study. And the reason for that is that and Shira, thank you so much. It's supported by OPLA, which is really important. It can be a very focused inquiry. It takes place during the interim, and some of us who know a lot about this issue could serve on that study. Going to give a shout out to Representative Henderson and her excellent service on the Right to Know Advisory Committee, which is a similar thing. But it's a really great opportunity to do a deep dive into a specific policy area, and members of this committee might want to join and or follow along with the commission. So let's talk. How does that sound to committee members? Okay, my instinct, I appreciate where you're going, but my instinct is the more narrowly focused it is, the easier it will be to hone in on the policy issue, which is parity. So can we take a moment to talk about who we would suggest to be on the committee? So Janet, there's a typical number of legislators, is that correct?
I think I left my rule book back. I think there is I can't remember if it's 13, you're supposed to have less than that.
Yeah.
And the theory is that the majority of the members should be legislators. I have rarely seen that. My very first study was just 5 legislators, and they invited everybody in who they needed to hear from. But the 5 legislators, so it has been done before. I would not suggest something like 29 people. And that's not meant meanly, because when that particular study was done, we had to do it on Zoom. So it didn't have the same kind of, space restrictions and everything else. I'm thinking about making it manageable. The rules do contemplate that you would have a majority of legislators, and there's nothing that stops you as a study commission from inviting people to speak, or as the legislature from directing the study commission to invite certain people to speak. So if you think these perspectives are important, you can direct that not just by putting them on the study, but also by directing that input to be sought and received. I don't know if this is the right topic, but sometimes people really want the public to be given an opportunity to talk, and you put it right in the study. So you can kind of guide how the study is done. I think a lot of legislators, when they're furiously writing a study, think you have to put somebody on it or you can't hear from them. And that's just not true. So think about if you've been on a study, how does it work with how many people there are? What would be the balance? Who is it, whose vote is it important to have versus whose information is it important to have? Those might be the same exact people, and that's great, but they might not be. And so that could really help you in your thinking process.
Thank you. Does anybody want to suggest membership? I can start if you prefer, but I'm happy to have somebody else take the lead on that. Representative Henderson.
I think the three most obvious would be the ones that are outlined, representatives from those that are outlined in the actual bill title. So representative, whether it be from the Prosecutors Association or someone that district attorney appoints. I know Shira had indicated someone from HR from the Attorney General's office, as well as someone from HR from PDS. Whether it needs to specifically be the HR person, or if we just say someone appointed by the Attorney General, someone appointed by Director Carpinian type of thing.
Yeah, I think maybe having both the HR person and then another representative who's more policy oriented.
Yeah.
As well. Okay, that sounds great. Other suggestions? How many legislators would we like on it? You're not invited. How many legislators would you, the legislators will be appointed by the House and Senate, so we're just looking for a number. So do we want to have 5, 6, 7, Representative Kuhn?
I feel like sometimes you see 5 and it's 3 from the House and 2 from the Senate. Does that sound right? Or is it 5 and 2?
I like
Representative Lee?
even numbers because I like to split or make them essentially bipartisan so that you're having an equal number of representatives. I mean, the Deed Fraud Commission was 4. It was 2 from the Senate, 2 from the House, 2 Republicans, 2 Democrats. And so I like that balance because it departisanizes it pretty effectively.
And this is an issue that we've worked very well and hard on together. So suppose we had just trying to think of how to allocate between House and Senate, but equal numbers. So maybe 2 senators, 1 from each party, and 4 House members, 1 from each party. I mean, not 2 from each party, excuse me. Okay, so that brings us up to 11. Others are listening intently. If there are committee members who want to make a suggestion, or those who are in the audience who wish to make a suggestion, or Janet?
So it's 11 because there's 6 legislators, somebody who represents the Prosecutors Association, and then 2 folks each picked by the Attorney General's office and PDS with a request that one of them be HR.
Correct.
Okay, just want to make sure I'm counting the same numbers. Thank you.
Did we end up with the same number? Great. Adam, my Representative Lee?
It also seems to me that there's another variable to compare these salaries to, which is private attorneys. And so someone familiar with the compensation of private attorneys in the state of Maine would be an effective thing to look at.
So who would that be?
Someone from the Bar Association, maybe?
We can see.
Yeah.
And yeah, my other thought would be somebody from the law school because of the whole supply issue, which is critical. Representative Henderson, and then was there another hand up over here? No, okay, Representative Henderson.
Thank you, Madam Chair. I'd like to dig a little bit more into that and just kind of see the relation between like how you made that connection, where this specifically is referring to taxpayer funded counsel, whether prosecution, defense, and specifically says that it doesn't have to do with the compensation granted for rostered attorneys, right? The $150 an hour. So when you talk about the private attorney side of things, where is that correlation for me?
It's a good question because it is sort of like, we have an apple, we have an orange, now this is like a kiwi. But the kiwi is relevant because you have people making a decision not only between being a prosecutor and being a defense attorney, they're also selecting to be a private attorney. And I would actually say that we have probably a compensation issue when it comes to private attorneys in the state of Maine comparatively too. So I think we would probably end up finding, I don't know what we'd find because I think the study would be interesting, but I think it deals with that supply and demand question when it comes to people taking these jobs.
Can I make a suggestion? How about instead of a representative from the Bar Association, maybe a private attorney from a firm that also does PDS work? How does that settle, Representative Henderson?
I was actually going a different direction in that that the conversations would, when discussing private attorneys, would be related solely to private attorneys, not ones that are rostered, not ones that do work for PDS. Because well, we were going to write this study, we're going to ask them what to do, but the bill itself specifically said that not to take into consideration or be compared to rostered attorneys.
Representative Lee?
I think in support of what Senator Carney was saying, I think that's a really valuable resource. I mean, I don't know how many there are out there who do both the private work and PDS work and have enough people and time to commit to the study. But if we can find that person who understands the compensation issues of doing that criminal defense work for some level of compensation, and not even PDS work, but like well, I guess now the department is PDS. So the private appointed work is what we used to call it. Someone who's making those decisions, am I going to take a private case versus am I going to take a rostered case? They have really invaluable information for us in deciding compensation.
Or,
questions.
or am I going to stay in my private firm, or am I going to apply for this opening either in the district attorney's office or in PDS? Yes, Representative Sato?
Thank you, Madam Chair. And I also think for that same reason, I do think it would be valuable to have someone from the law school to also serve for that same reason when we're talking, because I know that we want to keep the scope very narrow, but I do think that there is a relationship that has been brought up of parity in recruitment, and that I think the reason why we're talking about parity is because of recruitment. And so I think hearing from folks who are currently in private practice and someone who helps new lawyers figure out what they're going to do in their career is also important.
Yeah, and the way membership on the committee would work is, think of it as like a spider web. So the committee may want to hear about, the struggles of people making that choice. And so the private attorney from the firm that does PDS work would know who might be a good contributor to have them come in and speak at a public hearing that the committee, the study group would have. So what I've got is a representative of the Maine Prosecutors Association, a representative of the Public Defense Services, a representative of the Office of the Attorney General, a representative of PDS specifically focused on human resources, a representative of the Office of the Attorney General specifically focused on human resources, 2 senators, 1 from each party, 4 House members, 2 from each party, and then a private attorney from a firm that does public defense services, and a representative from the University of Maine School of Law. Does that sound well balanced? Additions, subtractions? Okay, not seeing any. Yes, Representative.
I'm just curious if either side has anybody that they feel would represent their cause or that, I don't know, that would have they know would have a better understanding of what both sides do.
So are you talking about naming an individual, or are you thinking about naming a category of membership to the committee.
Probably category membership, but I don't know what that name would
Okay.
be. So I don't know if either of them have a suggestion, if there's somebody they feel that would understand what they do that could represent them on the committee from
Okay.
either side, from both sides.
Can Freyla Tarpinian and Shira Burns, could you briefly address the committee? If you want to share any thoughts with us about the composition as it's laid out now and whether you have suggestions for any amendments to that composition of the membership. Yeah, thank you for rejoining us, Freyla.
Thank you. This is Fayla Turpinian again. To your question, trying to make sure I answer it. As I understand it, I think anybody who works at, so if you have somebody who works at the AG's office, or, so the Maine Prosecutor Association is made up by the AG's office and the prosecutors. And so if that's one prosecutorial position, anybody who works for either of those organizations is going to be able to tell you what they do. There's some variation, but it's not, it's the same court rules. It looks different in different courts, but it's very similar. And they'll be able to tell you about compensation. If you want to talk about how people get hired and how salaries get set, you're going to need someone in administration from the DA's or the AG's office, because they're the ones who do that negotiation.
What I guess I was trying to ask is if you feel like for your, for the public defender's office, if there's anybody that you feel would be a good person to represent you on this committee. And then likewise with the prosecutor's office, if there's somebody that they feel would be good to represent them on this committee.
Yeah, and so I'm just going to interject here that the way these studies work is that the Speaker of the House and the Senate President are the individuals who appoint specific people. So that might be a question for later down the road. Yeah, but as far as equal representation between PDS and the prosecutors and the DAs, do you have a concern that we haven't achieved that with this list?
If there's two people if there's one person from the MPA who is only prosecutors in the AG's office and one person from the AG's office, they do have two people and the PDS has one person. I would point that out. You could balance that by somebody from MACDL, but that's likely somebody who takes our cases. I assume many of you know this, I don't want to make assumptions. There are very few defense attorneys in the state that don't do, or at least haven't done, PDS work. There's a very small handful. I don't think any of them have never done a PDS case. I won't commit to that, but it's a very small number of individuals. That would be my observation.
Okay. Yeah, great. Thank you. And Shira Burns, could you join us and share any thoughts that you wish to share? Thank you.
Thanks, Shira Burns, Maine Prosecutors Association. I think the representatives are correct. I guess I wanted to clarify, and my answer will change based on the way this direction is going. My understanding was that everyone agreed the policy, in a sense, there should be parity, and that was always meant to be. Just how we're formed differently, it may not look like that. And that's what we're just trying to get at, is what would parity actually look like? If that's everyone's assumption, that's good. If there is not consensus or unanimity regarding that prosecutors should have parity or defense attorneys have parity, then I think I would want to talk about that list a little more, in the sense we're starting to advocate then of what we do, our workloads, our caseloads, our on-call, stuff like that, of why we deserve the same pay. And those to me are two different, and there is some additional things I think we need to put on, like a frontline ADA and a DA, if we're starting to advocate for why parity should exist, than just looking at what is parity.
So stay there for just 1 minute. Committee members, are we interested in asking the question, what would parity look like? Is that what we're looking for?
Yes.
Okay. And then how would you feel about the suggestion that someone from MACDL also join the be a part of the committee.
Yeah, I mean, I never mind if it's even, I thought you said there was, I mean, somebody from Defense Council already on that. So
Yeah,
I
a
did
private
ask-
attorney, but yeah, a private attorney from a firm that does PDS work.
So I thought that would be two
Yeah.
and two.
Yep.
But again, if the policy is we all agree parity should happen, then it really doesn't matter to me.
Okay, thank you.
Yep.
Committee members, Janet, are there other questions that you have for us?
I do have one question.
Yes.
Is there a desire to switch from an attorney who does PDS work to MACDO or both? I just want to make sure I have it right.
Personally, I liked having the private attorney from a firm that does PDS work because that way we incorporate that perspective of, what are private attorneys? What are their lives like? And their.
Okay. Then the other thing I wanted to say is, the legislators would be the speaker and the president. I would divide up the representative from MPA, the private attorney, and the law school between the speaker and the president. I'd probably give more to the president because they get to pick less legislators. But I think for OAG and PDS, you would ask them to designate. That's the more general way you do it.
Great. Okay, that okay with everyone? Yes, Representative.
The only question I have is how do we know that they're going into this feeling that there is parity without having to have?
I have a suggestion for that too. So we recently talked about the probate bill. That study was set up, it said, make a plan to do this. It didn't say, should we do this? It said, make a plan to do it. So that's in the wording, you don't say like, examine whether there should be parity, say, examine how to make parity happen. I will try and use better words than that. But I think you can frame it very specifically with the assumption that that's already understood. And if you want to put an emergency preamble on it, then you can add like flowery language about the importance of parity. So.
That sound good to everyone? Okay, Senator Rotundo?
Thank you for allowing me to speak. I'm still, thank you, Rotundo, from representing Senate District 21. You have to forgive me, but as chair of the Appropriations Committee, I'm constantly thinking about how you do things as inexpensively as possible. And I just, and I'm not saying the committee should do this, but just something you might want to think about. Legislators who serve on commissions need to be compensated. And so the more legislators you have on a commission, the more expensive it is, and the less likely it is that it will get funded off the study table. We aren't talking about an exorbitant amount of money, having 6 legislators as opposed to 4, but I felt I needed to share that because I really want to see this go forward, and I don't want anybody saying, oh, it looks a little expensive to me. They've got all these legislators on it and not have it funded for that reason. I don't have anything to do with the study table, but I've watched how it works over the years, and I know that can be a factor. And I know there have been commissions. I was on one a couple years ago that had a senator, a Republican and Democratic senator, and a Republican and Democratic House member. And I don't think the House felt too slighted. We were all equals and did good work. So thank you for letting me share that. Thank you.
Thank you. That's so much appreciated. Representative Lee?
I'm totally not opposed to that either. I served on one where it was 2 and 2 and actually thought fewer legislators made less focus on the legislative priorities. It made it more on the subject matter experts feeling involved in discussions. So I'm not opposed to 4.
Is everybody okay with that? Economizing shift? Okay, good. Committee members, another question. Oh, yes, Representative Kuhn.
I was going to offer to make a motion
Go ahead.
Okay, I'll move ought to pass as amended on LD 374, changing it to a study as we've described, with the most recent change included to bring it to a total of 4 legislators.
Is there a second? Seconded by Representative Babin. Janet, do you have questions for us before we launch into discussion?
No, I understand. I just want to be sure that it's going to be drafted as if parity is assumed to be the goal and just about how you get there. I think you wanted to focus on compensation and the total compensation packages. Is there anything else you want me to say in the duties? It can be very brief. There's nothing wrong with a very focused duty.
I think the other point was what else is needed to achieve parity, thinking about collective bargaining. And I think somebody mentioned job security concerns. I think that's a little bit related to the collective bargaining, but Representative Kuhn?
I don't know if we need to specify this, but I think one component is looking at parity at different levels of seniority, so that it's not just the initial recruitment parity, but that it retains parity throughout the career cycle.
Anything else, committee members? Representative Henderson?
Thank you, Madam Chair, and thank you, Representative Kuhn. I think that not only looking at the like the longevity of someone being there, but also the amount of experience that they come in with. And I mean, I know this has been talked about before, that PDS employees are unionized, but I think that that should also be a big part of the discussion, that you know, that they do hold within their own power to bargain for wages. I understand. And although at first initial hiring has standards that are set, that they do have a collective power to be able to bargain for their own wages. So I think that should be something that's taken into consideration as well.
Anything else, committee members? Okay, thank you everyone for those contributions. Committee discussion. Anybody like to engage in committee discussion? I am not seeing any hands up. Is the committee ready for a vote? Seeing nodding heads, looks like the committee is ready for a vote. Thank you, Clerk Panett.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan.
Yes.
Senator Hagan votes yes. Representative Poirier. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Representative Poy. Representative Poirier is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 11 members voting in the affirmative, zero in the negative, 3 members are absent, and that is the vote of the committee.
Thank you very much. And so committee members, the ought to pass as amended motion carries, and we'll see that on language review. And so we'll close the work session on LD 374 with thanks to everyone who joined us, and special thanks to the sponsor. Okay. Thank you. And
Here in the parity.
Committee members, you'll notice that you have a nice violet piece of paper in front of you, or several pieces with a stapler. This is a preliminary language review on 524, and Janet, I'll let you guide us through it.
So there's two reasons for the preliminary language review. The first is that when you made the motion, you said to add an emergency preamble and to incorporate the proposals from the Criminal Law Advisory Commission. And I mentioned I had a few questions for the Prosecutors Association about some things I thought were a little bit off, like not lining up in the bill. So I want to show you the outcomes of those. In addition, we talked about during the vote that there was a concern about whether the way that the obscenity test for purely AI generated images, whether the language of that obscenity test and all of the words used were really required by case law. And so at the invitation of the AG's office, I reached out to the AG's office and I did get answers back. So you can see the questions I asked on the back of the first page, but the answers we received really I focused on two questions that I understood to be the crux of what the committee was discussing. The first was that throughout the amendment, whenever obscenity was the test, there was first the three-part test for obscenity from Miller, which is in the definition section of obscenity, which is the community standards, average individual word we don't agree on how to pronounce, prurient interest. Part B is describing or depicting in a patently offensive manner certain sexual acts, excretory functions, etc. And then C, considered as a whole, lacks serious literary, artistic, political, or scientific value. That's the three-part test from Miller, which is the US Supreme Court case. Then if you actually look at the actual provisions that just create the crime of AI generated or fully computer generated, could be, I don't know, maybe something other than AI can do this that I'm not aware of. If you look, for example, on page 3 of the amendment that I included, under 282A3, this is the new completely technologically created CSAM. There's that second paragraph saying it doesn't apply to non-commercial dissemination, distribution, or exhibition for purely educational purposes at certain types of institutions or commercial distribution by an art gallery or museum. Folks were very concerned about that. When I reached out to the Attorney General's office to ask if that language is necessary, do remember it is in current law for the law making it a crime to disseminate certain obscene materials to minors. That's where the language came from. The Attorney General's office had Chief Deputy Attorney Christopher Taub answered, and he does not believe that that language is necessary under Supreme Court precedent for the obscenity test. So I wanted you all to have that answer. I knew it was very important to folks to see if you wanted to include it or not. And then the other question that came up was this question in the Miller test. We talk about that first question, to the average individual applying contemporary community standards, does it appeal to the prurient interest? And there was a question, shouldn't that be reasonable individual? We talk about reasonable individual all the time in this committee. And Chief Deputy Attorney General Taub's answer was that reasonable individual is really a tort-like question about the types of care a person should be taking. An average individual is the exact phrase used in the Miller test, and it's an average individual's assessment of the community standard, not an outlier individual, which is a different concept than a reasonable individual. And to the extent they're the same concept, maybe keeping the language of Miller, I think, is what he would suggest you do. Hopefully I didn't mischaracterize his email, but you have it. So I wanted you to have that. So those are the two questions you asked him. Then if you want to actually see the language of the amendment, I added the emergency preamble, so that's on page 1. See if you're okay with that language. On the bottom of page 1, I circled the word depiction in the definition of child sexual abuse material. That word was minor in the version you saw at the public hearing and at the work session, but when CLAC looked at it, they thought the word depiction fit there better. So I made that change. I ran it by the Prosecutors Association. They didn't have an objection. In the definition of obscene material, we talked about that paragraph A, the average individual, contemporary community standards. in the version you saw at the public hearing, it talked about how that, I actually have the language on the last page. It also said, with respect to what is suitable material for minors, which comes directly out of the distributing material to minors statute, but that's not what this is about. So CLAC said you should take that language out, so I did. You could tell me to put it back in, but you said to follow the CLAC suggestion, so I wanted you to see that so you would know. This is on page 2, 3AA. So it was a CLAC recommendation to tighten up paragraph A to match the Miller test. And the language that was removed, I explained on the last page to remind you of what CLAC had proposed to change. And number 3, I gave you the quote of what was removed from that language. Sorry, that's in 2 different pages. That probably wasn't the best approach. On page 3, if you remember, throughout this amendment, you're creating 2 types of new crimes. There's the morphed images crimes, and then there's the purely AI crimes. And in the dissemination and possession crimes involving morphed images, that exception for the teenagers relationship exists. It was not included in the morphed images for creation. When I spoke to the Prosecutors Association, that was not an intention to avoid using that teenager defense. They wanted it to be consistent throughout. So it is added back in here, and that's in A2 on page 3 where I marked it. So if you are creating a morphed image and you're in a relationship with the person who's being depicted in the image, that person is 14 or 15 years of age, you're less than 5 years of age older, you have the same defense as if you took an actual picture of them to make that image. Does that make sense? Okay, so that's what that changes. It's my understanding they meant that to be in there all along. I don't know if I made that mistake originally. I don't know. The next one on page 4, this is actually an OPLA change. So on page 4, you'll see this is the part that's the evidentiary rule. This rule is currently in statute for possession offenses, and it talks about reasonably inferring from the contents of the image, the age of the person depicted, the age of the person who appears to be depicted, or that that person is an identifiable child. And the word person was used throughout. On OPLA review, it was suggested to change it to individual because if you look at the way the criminal code is written, and even in all these statutes, person is usually used to refer to the defendant. And just in case there's any confusion, it's individuals in there, defendants, victims. It's not just about the defendant. Current law does say person there. I don't think people have misinterpreted it, but it was potentially an opportunity for clarity, and that's what my reviewers suggested. I thought it was a good idea. But you can obviously disagree, and I'll change it back. So that is again on page 5. On page 6, this is the possession offense. Remember, if you engage in creation or dissemination of these images, person under 16, you have the certain class of crime. It's elevated if the person depicted it or appears to be depicted as under 12, or if you're a repeat offender. In the possession world, it's elevated if the person's under 12, and it can be elevated again if you're a repeat offender. But we forgot to put, to make all of that line up. So if you look above paragraph D is paragraph C1, that says you violated the law about these images and the person wasn't 12 years of age, then that's enhanced. Paragraph C above it is the existing law about you violated existing law and the person's under 12 years of age. That's enhanced. Then paragraph D does that second enhancement up, but we forgot to add the new paragraph C1 in there. So that's going to be added so that everything lines up, because it was my understanding your goal is not to change classes of crimes or anything, just to address technologically altered or created images. So that's the other change there. And then if you do an emergency preamble, you need an emergency clause. The one last tiny little change, it's throughout, is I used the words is less than a certain age. CLAC pointed out that throughout the criminal code, they talk about have not attained a certain age, and they thought it was really important to use consistent language. So I put that language all back.
So I'm going to turn first to the bill sponsor and ask you to address the suggestions on the draft language.
Thank you. I think those are great, great changes. Thank you for your care in doing that. And then I think the only outstanding question is whether we want to remove the entity level exemptions that we received new information about from Mr. Taub.
Representative Lee?
My advocacy for that provision at the last work session was based on the concept that it was needed in order to comply with First Amendment requirements. If that language is not, where did that language come from? And I just want to hear the rationale for including that language.
So in Title 17 currently, there is a crime for disseminating obscene materials to minors. That is in that book. It's near the end of the book because Title 17 is near the end.
Yep.
I have it marked on my thing, but I left it in my other office. Sorry about that. And that exception is in there. And my understanding was that the Prosecutors Association wanted to take obscenity the way it's currently defined in Maine law and just transfer it over. That's why we had that weird phrase about what it looks like to children, because it came from that statute. So Clark pointed out that doesn't really apply. We're not disseminating only to minors here. We're talking about disseminating more generally. And they also used that exception because it's in current law, is my understanding. And then when the AG's office looked at it, they said that may be in current law, but we don't think it's necessary for obscenity, First Amendment purposes. You might think it's necessary for other policy reasons. That's up to you. That's my understanding.
Okay.
I don't know why they put that in there back then. That's
Yeah.
an old statute, it's Title 17.
It makes me super anxious to remove something that was included so that we don't screw up a already constitutionally tested statute. And so I don't know if Deputy AG Taub, or we definitely have someone from the AG's office here. I apologize. Yeah.
Andrew Bergeron from the Attorney General's office. If you could repeat your question, I'm sorry,
I don't even know if I had worded it as a question. I just have, I absolutely see the rationale for including the language in the initial draft of the bill. I'm now weighing that against what we have from Deputy AG Taub saying it's not necessary, and sort of trying to situate myself when the original statute that we borrowed the language from was enacted, why it was included. And I would have presumed that was because they thought it was necessary for First Amendment purposes. And so I'm dealing with a historical reality that says we needed this language, and now an opinion saying we don't need that language, and trying to square those two in passing this bill.
Absolutely. And I'm just putting two documents I have side by side just so I have them. I don't want to misstate when I say what I'm about to say. I know in draft, so I'll give you a longer answer to a shorter question, I guess, but okay, fair enough then. I'll match you. When the drafting was done of this, it was the intent to take exactly what was existing approved law there that we knew was stood up and transpose that, because we knew that obscenity was under Miller and under Maine law, solid case law, solid drafting. And the motivation at that point was to, I think, be as conservative to the current understanding of the law, and to know that that language is in place was solid. I think it was belt and suspenders on the definition of obscenity, and I think it applies specifically to that Title 17 statute of providing to minors. Looking through the Miller test and looking at obscenity, one of those definitions is going back and something that lacks serious literary, artistic, political, and scientific value. I think Deputy AG Todd's reading of it, that definition of obscenity covers essentially what is repeated in that one paragraph. And so I think that's the understanding. And I know it's not exactly what you're asking, but that was the motivation of transposing that language. Was there are several cases before Miller, but they all say what Miller says, in that there are the aspects that something where you get into literary, artistic, and scientific value, that there is a weighing of First Amendment rights. And I think that's just why that language was adopted. We wanted to be as true to what was existing protected law, because it was, again, a very much a surgical approach to just what we knew then. That's.
Yes, Representative Lee.
I think I think it does look like belt and suspenders to me. I'm just really having some anxiety about taking off the belt, I guess, is where I'm at right now.
And I can just say that the language of obscenity matches Miller. And that's where, looking at the not knowing, that I cannot speak to what the legislative history was on the original Title 17. I can't tell you why that's there, but I can, in looking at what the proposal is, coming back to that test, is it does cover what that is contemplated. Sorry, end of the day.
Representative Kuhn.
Thank you. I guess I'm trying to understand whether, what the harm is in leaving it if it feels tested. I mean, has this ever, in your experience, been actually used as a safe harbor? For someone
Not in
to
my
avoid?
experience.
No.
I not in my personal experience.
So it's not actually limiting enforcement in any practical sense?
That I have seen.
Okay, thank you.
Other comments, questions, discussion? Not seeing any. Thank you. Oh, yes, Representative Kuhn.
So just in your opinion, as someone who's going to be charged with implementing this, do you have an opinion on whether it should remain in terms of your ability to hold folks accountable, remain or remove?
From my position as prosecuting CSAM cases and internet crimes against children, I don't see it as a block to what we do in the cases we investigate.
You don't see keeping the language, or you don't see removing it as a
I don't
block?
see where having that language is going to cause a defense to somebody that we would be investigating. I don't see it as an exception or a bar.
It's not a barrier to prosecution.
Barrier, yes.
Thank you.
For what I see in my cases.
Thank you. Other questions, committee members? Yes, Representative Sinclair.
Thank you, Madam Chair. Good afternoon.
Afternoon.
My brain may just still be tangled on this same issue that I've tried to broach before. I'm wondering if you can take one more stab at helping me navigate my way through parsing the definition of identifiable child at the top of page 2 in 1C. Because it looks to me, if I look at the first line of 1C and the last line of 1C, along with the lines that come in betwixt, it looks to me that we're describing an identifiable child that doesn't require proof of the identity. I'm not sure how those two things go together.
Only because I was reading and getting my page set. I don't mean to. Can you restate your question just so I?
Yeah, can you help me understand the definition of identifiable child, which seems to require both that the person is recognizable as an actual person by a number of different criteria, and then also either was a minor at the time or whose likeness when the person was a minor was used in creating. How can we require that and also say that identifiable child does not require proof of the actual identity? How do you prove it was an identifiable child if you don't prove who it was that supposedly was identified? What am I missing?
I think that's a factual determination for the jury, is what that is. That's where it's going to come down to.
How do you get one without the other is what I'm trying to understand.
Can I try? Okay, let's let, I'm sorry, I didn't mean to intervene, but I have a thought.
I'm not following so. It's an actual, I'm sorry again, can you just rephrase this? Because I'm not tracking.
Shira Burns might be able to answer that question, if that would be helpful to you, Representative Sinclair.
I don't know if it would or wouldn't.
So how we, the way we prove these cases now, if you don't know exactly who it is we can, one, bring in evidence that it has been identified by someone, which we're not talking about, but you could also bring in evidence of a forensic nurse or medical testimony that could say that is or is not consistent with somebody who is 8 years old or that kind of development. That's how that would be proven. When you have certain cases with CSAM, some of that expert testimony may be conflicted with what this was AI, and therefore that evidence can't be solicited. Or am I missing your question?
I did want to point out that is the federal definition as well. That says that.
I don't doubt it. I'm just trying to understand where this is going, because it looks like it's both that we're saying an identifiable child needn't be an identifiable child. And that's the part that's hard for me to understand.
I'm going to recognize the bill sponsor for a moment.
Thank you. I think where it says actual identity, I think they mean literally the person. So it's like, they don't have to be able to say, this is Sue Smith in Pasadena, California.
They just
Which is different than the idea of identifiable child.
Yeah, you have to, like, if you saw a picture of a child from another part of the world, you could look at the picture and say, oh, I know that is a child in the city of Rome, but you don't have to know that it's whoever from Rome. Shira Burns, could you please step forward and also.
That is consistent with my understanding.
Okay.
Yes, I'm sorry. That is consistent, Madam Chair, is my understanding as well. I guess I just didn't understand the question. So.
Thank you.
It may have been that I clumsily worded it.
Pardon?
It may have been that I clumsily worded the question. Don't fault yourself.
No, I'm sorry.
Shira Burns, Maine Prosecutors Association, and I don't know if I can clarify more than you just did. That's exactly what it is. Current law as it stands, we don't have to prove the actual identity of the child. We don't have to do that now. We don't want to do that later. And that is what it's saying. We do have to prove under the concept of identifiable child that it is an actual child. And we do that. We can have experts come in. What we've been saying about this, though, is that's getting harder and harder. And that's why we really need the other part of this bill of the fully generative AI, because to distinguish of what's fully AI, what's morphed images, what's fully a child is harder and harder. But all of this, that identifiable child is just saying right now, under that section, we have to prove parts that is an actual child that's involved, but I never have to prove that's Shira Burns, who's 6 years old.
Yes, Representative.
And how would you prove that it's an actual child without establishing identity?
So they do it, it's done all the time. They do it with experts. They do it with experts from the crime lab about like that. If you're talking about if it's an AI generated, they have, Lieutenant Richard's still here. They currently have the ways to do that. They have experts. It used to be, I mean, I'll say it's all evolved because it used to be just pictures, and then you'd have literally the expert come in and say, based on these genitals, all this stuff, it would be all medical. And I think it's even addressed in this bill that allows us to do that, because it's always been allowed in part of the section. So we can use medical, and then we are now using experts in the field of AI, of generative, to say we can tell that this was a morphed image based on all those terms I don't know. And it's our burden. I mean, that's why we would have to pick, do we charge it under the identifiable child? Do we charge it under the wholly AI? And we're probably gonna eventually in 10 years not know and have to only charge it on the generative AI.
Representative Kuhn?
I was just gonna add, this gets to the point also where like having to prove that the content was created before 2022, like it pre-existed in some other form, because after that time, you could always argue that it's not an identifiable child because it could be generated.
Correct.
Questions, committee members? And I am not seeing any. Okay, thank you. So,
Can I just,
yes,
I've
Representative.
done like my 30th reading of Deputy AG Tubbs' email. And I'm wondering if what he's saying, and other people can help me out here. I'm wondering if what he's saying is because that language is already in Title 17, we don't need it expressed in the general rule regarding obscenity. We don't need that language in this bill because it's already statutorily there in Title 17 when assessing obscenity. You don't think that's what he's saying?
He could be, I'm not him, but the way I read it is what he is saying is that Miller requires you to consider as a whole whether it lacks serious literary, artistic, political, or scientific value. That's what's required by the case law. You have that in your test. I believe he's saying you don't need to also say, we're going to consider if it was non-commercial from this type of institution and there was an educational purpose, we know it's going to fail the obscenity test, so you just don't even have to ask. I read it that way.
Yeah.
Do you have a recommendation, Representative Kuhn? Is this your legislation?
I mean, I guess, I think we would all agree we don't want to create a loophole accidentally that would cause the overturning of a conviction. And it does sound like defendants are not taking safe harbor under this now. So I guess I'm torn about it. I mean, do you have a recommendation of what would be the stronger way to word it? Because I'm fine with, no, you don't. I would be
feel
fine
like
with going
that's
with that.
what the AG's office is for.
Yeah. And I guess we heard them say that they don't think that leaving this here does harms in any way their ability to prosecute. So I guess I hear that as saying no harm in leaving it there. Is that how others?
Representative Henderson?
Thank you, Madam Chair. And thank you, Janet, for reaching out to the AG's office. This is, I really grappled a lot last week with trying to figure out the connections. And I think once I stopped looking at this as an exemption and started looking at the educational and art galleries and museums as more of a pass-through to determine what is or isn't obscene, rather than we're just exempting all these entities from being able to be prosecuted for having this. And once I started to understand that, pieces started to make more sense. I hesitate with writing law or supporting law that is just duplicative in nature. And I think there've been other pieces of legislation that have come before us where testimony has been given that says, I don't really think that this does a whole much. It's not going to change anything that I haven't supported. I know Representative Eaton, I think in 24 perhaps, had a bill that came forward and that members on this committee did support. I didn't, because I just felt like it's duplicative. And I think that's kind of where I am here in this, is that definition of obscene covers the test. That quote unquote, what we've been calling exemptions, which I'd love to find a better word for it, is already written in Title 17A. And actually, the definition of obscene is in that portion of dissemination of obscene matter to minors. But this specific or significantly expands that definition that is written in subsection 2911 under the dissemination of obscene matter to minors. So if we want to talk about belt and suspenders, I think that just expanding the definition of obscene material in and of itself is actually creating a really good protection. And I would be really apprehensive, because this tends to always be the way that I go on things, is to try to create a strong law that is least confusing as possible, not duplicative. So I would be in support of removing the non-exemption, whatever that piece is, and just giving it, because that obscene material already addresses the three-pronged approach in the Miller test.
Yes, Representative Lee.
Because I've been enough of a pain in the butt, I was just informed via text message that Chris Taub is on his way over, so.
Fantastic.
I'd say, I think I'm gravitating towards that opinion, reading what Chris Taub wrote. I would certainly not want to repeal it from 2911. And that's sort of, I think, my red line is what I'm thinking of.
Sure.
Yes.
And I think I know very much so that from the beginning of this, it has been my intention to not touch any other piece of law, right? Like, this is really carefully crafted. It's other areas of law have come forward that I don't really care for. That has made me realize, I think there's some things that I think we should debate at some point, other bills that will be forthcoming. But for this one specifically, let's just put this intricately woven piece of something in place that fits. So I would agree that 2911, I don't think that we should touch that.
Other comments? Yes, Representative Sato.
Thank you, Madam Chair. I think I'm definitely leaning, I guess maybe where I'm standing right now is balancing duplicative law and confusing law and whatnot versus the risk of a First Amendment challenge that could undo this entire piece of law altogether. And so I think I'm actually very curious to hear what Christopher Attorney Taub says when he arrives, because that for me, I think that's the sticking point for me, is keeping the paragraph in or keeping it or taking it out is for me about risking having the law overturned completely eventually. So.
Yeah. Welcome. Yes. Please join us, and if you could introduce yourself.
Hi, everyone. I'm Chris Taub. I'm the Chief Deputy Attorney General.
Thank you so much for listening to our discussion and heading over here.
I confess I have not been monitoring it, so
Oh, no.
I understand just very, very generally what you want to talk about, but I have not been keeping track of this.
Okay, then I think the way we're going to start is we're going to have the bill sponsor, Representative Kuhn, ask you a question.
Thank you. So we're reviewing your response to the questions that Janet posed and looking specifically at the, for lack of a better term, exception that exists for library, art gallery, museum, public school, private school. We interpret your memo as saying that that language isn't necessary in order for it to pass scrutiny, but we're also hearing that concern from the committee that the stakes are high. We wouldn't want to have, a prosecution, for example, overturned on First Amendment grounds because we removed this when it was specifically included in order to line it up with other areas of law. So wondering if you can just expand on that for us and make a recommendation if you.
Yeah, so
you have
let me
one.
just, this issue came up a number of years ago in the context of another statute that has the same language. It's the criminal dissemination of pornography. I don't know if that's the exact phrase, but it's in, I think, Title 17. And I remember it came up at that time because there was concern among some people that school libraries had pornographic books that they were allowing access to students. And so there was a bill that was proposed that, oh, thank you, that would have stricken schools from that exception. And I remember that we looked at it at the time, and our conclusion was that it wasn't really clear what that exception is even doing, because the definition of pornography already, for reasons that the First Amendment requires, something can't be pornographic if it has serious literary value or literary artistic or so. it didn't seem to us, and we couldn't understand why there was a specific exception for schools or art galleries or these other kinds of institutions, because really by definition, the things that they would have by definition would not be pornographic because presumably they do have serious literary, artistic, so on. So that's just the context of when we first started looking at this. But we didn't really do a deep dive. I didn't look into the legislative history to see exactly why that exception came about. I can say that we don't think that this is an exception that a quick research shows this is not an exception that we've seen in other state pornography laws. And it's not required under the Supreme Court's test. I mean, what's critical to the Supreme Court's test is that there is an exception for works that do have serious literary, artistic, and so on. We've never seen a case that suggests that it's required to have a carve out for specific types of institutions. So we've never seen a case that says you have to specifically carve out libraries or you specifically have to carve out art galleries. It's just that you have to make sure that you do carve out works that do have some serious, significant value to them. So I guess a shorter way of saying this is it almost seems as though it's just redundant to have that exception, because presumably you're not going to get to that exception with respect to art galleries and libraries and so on. So I don't know, does that help at all, or?
First, Representative Kuhn, did you wish to react? And then we'll recognize Representative Lee.
I was just going to say thank you. That really helps. That's really clarifying.
Representative Lee?
Super helpful. I think one of the things we were talking about is just sort of like do no harm with this statute and don't create any unintended consequences. And so this was incredibly helpful as to adding the language there, but we don't want to touch where it is in 17 for fear of those consequences.
That would be for what it's worth, that would be my advice, because again, we didn't do a deep dive into the Title 17 provision. Maybe there's some nuance that we're missing. So maybe there is some reason why it's important to have it there, but we don't see any reason why it would be necessary with respect to this particular bill.
Yes, Representative Sinclair.
Thank you, Madam Chair. I'm not advocating either way necessarily, but to me, there is a difference between including or not including that. I'm going to use the same phrase everyone else is using, exception. And the difference is in one instance where you include that, you're looking at the motivation behind the entity that disseminated or displayed the material. And in the other, you're looking just at the judge or jury, the fact finder's interpretation of whether that material had serious educational, artistic, et cetera, ad nauseum. So I think there's a fundamental difference in what we're looking at with the two, and including the exception as it is now toward the bottom of page 4 makes sure that we also look at the motivations of that entity, so that presumably the intent is so that those who are tasked with putting together artistic displays or educational displays are in a better position to judge whether something might have artistic or educational value than a randomly selected juror.
Yeah, Representative Caruso?
Thank you. Would it be a benefit to ask Shira Burns if her feelings on this?
Yeah, it is always a benefit to hear from Shira Burns and everyone who appears to help us. Chris Taub, if you can please remain with us, because I feel like this is a deep conversation that we want to continue to work on and resolve this afternoon.
Shira Burns, Maine Prosecutors Association.
So I was, do you feel strongly one way or another in terms of making sure you have a conviction?
After speaking to Deputy Chief Taub, I also did pull the legislative history from 1975. I emailed the reference library as soon as we got out of this last one. I did go through, I have the email here, through the original bill did not have that language in it. It came in an amendment. The committee file is not there though. It is from 1975. I did go through the floor and the different floors about the talk. They were very focused on not limiting what schools can have. It wasn't actually about First Amendment. And there's actually even an AG's opinion there about another LD, which I was like, oh my gosh, an AG's opinion, great, pressed on it. And it was about adult magazines. So there was nothing in there that made me like, oh, we have to have this. And then we did go back to all of the case law, talk to the AG's office, emailed back and forth. And I will say, I feel confident that we'll be able to prosecute these cases and hold up on appeal without that paragraph based on all the conversations and research we did in the Miller test. That being said, if this committee wants to keep it in, I also don't see it as an impediment for us being able to prosecute. Also, I talked to Lieutenant Richards, I swear he was here. So when I'm coming back in, and he's like, none of this is going to apply anyway, because this is only talking about fully generative AI stuff. We're not talking about what's like history about how it applies with real children, and why that needed to, why there's these exceptions existed before. We're talking, this paragraph is only applying to, again, that fully generated AI material. So I guess we are fine with you taking it out. We are fine with you keeping in. We'd love this to be a unanimous report. So whatever gets you there, we will go along.
Thank you. Any follow-up questions for Shira Burns? I think we've come to a decision point, perhaps, committee members. Janet, is there anything that you think we're not looking at that we should look at?
No, I would say that there is a little bit of more detail under the lacking serious literary, artistic, political, or scientific value. That's like added, that kind of looks at motivation. I don't know if it addresses all of Representative Sinclair's concerns at all, but it might be useful to kind of just read that whole paragraph, see with the subparagraphs as a whole. It's because that's what you're comparing to the other paragraph. Do you also need the other paragraph when you have C with sub 1 and sub 2?
I think I'm just, can you just walk us through that again one more time, please?
Okay, so the Miller test is, if you look on
What page are
page,
you looking at?
if you look on page 2,
Okay.
the Miller test is what is listed in the definition of obscene material as A, B, and C. This amendment language from the Prosecutors Association, their work with others and stakeholders, adds subparagraph 1 to A, and it adds subparagraphs 1 and 2 to C. So I think if you are looking to try and figure out if you personally want to include or not include that educational purposes language, you need to compare it to C with the subparagraphs. Do you feel like the way that is written is enough? Or do you feel like you also need this other language? Because there was some question about, are we looking at motivations and things? And I think those subparagraphs are kind of getting at that, but maybe not to the degree you want it to.
Thank you. Yes, Representative Caruso.
I appreciate that. My concern is that we are also thoughtful and trying so hard. But they're the ones that are trying to get prosecutions and convictions and everything. And if they are thinking, if they're not telling us to think that way, then I don't know. I don't want to jeopardize them from getting these convictions by us overthinking it.
I just weigh in. I would like to do the least risky option, but you had your hand up, Representative Kuhn.
Yeah, I mean, I think we're hearing that they're not perceiving either route as being extremely risky, but I do think I personally could go either way with it. I do think it's really important that we produce this unanimously. And so I tend to feel like we should be very cautious and just leave it alone. And especially if other legislators are going to be looking at this area of law in a very comprehensive way next year to possibly make other changes, that could be part of that evaluation. So I'm leaning towards just leaving the vote that we have, but if others feel strongly, I certainly want to get on board with a unanimous opinion.
Representative Lee?
I join you in wanting a unanimous report, and I can accept either, given what I've heard. My overarching concerns about removal of the language, I think, are resolved by the continued existence of it where it presently exists. And so I can accept either, but I want a unanimous report. And so in that interest, if nobody else has anything to say, I might suggest that we take a corner caucus.
Okay, all right, let's do that and try to come back at 4:35, everyone. Thank you. Committee members, please take your seats. And I'm going to recognize Representative Kuhn.
Thank you. Having voted on the prevailing side, I would move to reconsider.
Is there a second? Seconded by Representative Lee. Let's do a roll call vote on this. Did you wish to discuss? Just a minute, everybody.
All right, and right fast.
You're doing great. Thank you.
This is the reconsider, is that correct?
Motion to reconsider.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan.
Yes.
Senator Hagan votes yes. Representative Poirier. Representative Sinclair.
No.
Representative Sinclair votes no. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Representative Poirier. Representative Poirier is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 10 members voting in the affirmative, 1 member voting in the negative, 3 members are absent. And that is the vote of the committee.
Thank you. And so the motion for reconsideration prevails. And then I would recognize Representative Kuhn for purpose of making another motion.
Thank you. I'll move ought to pass as amended, as it exists in the purple language review with all the changes from CLAC. And also removing the paragraph that's been under discussion in each of the 3 places where it appears.
Does everybody understand what the motion is? Does anybody wish to second it? Representative Henderson, can you just turn on your mic and indicate you're seconding it? No, but just please turn your microphone on.
To do what?
Second.
Oh, I second.
Thank you. Just because nobody who's watching among everyone who's watching us can hear us if we don't have our microphones on. Senator Hagan.
Thank you very much. Could you just, I want to make sure I don't cross off the wrong ones. Just go over, tell me which of the ones and what page so I can just cross them off.
Yep. Oh.
So if we look, the first place it appears is on page 3. It's section 282. 1A3. So it's the second paragraph that starts with this paragraph does not apply to any non-commercial. That paragraph would be stricken. And this way I can tell if I'm doing what you want. The next one is on page 4. Under 283 1A1. Again, this paragraph does not apply to. It would be that paragraph stricken. And the last spot is on page 6. So that section starts on page 5. It's 284 1A-1. And it's again at the very top of page 6. This paragraph does not apply to non-commercial. That paragraph would be removed. Are those correct?
That's correct.
Thank you.
Any other questions, committee members? Any discussion? Is the committee ready for a vote? Representative Sinclair?
Thank you, Madam Chair. Madam Chair, I just wanted to quickly explain both to my committee mates and to anyone from the public who may have watched or have reason to watch in the future, the reason why I voted against reconsideration. I think that removing those paragraphs that we have just removed, presuming that this motion passes, I think that we actually make the statute less powerful, less strong, and ultimately less in compliance with First Amendment. Our First Amendment jurisprudence in the state of Maine for a long time with respect to threats looked only at how the reasonable person would interpret the communication that had been charged. The Supreme Court recently, fairly recently, and it's oldish now, a year and a half ago or so, decided that that the voice of the defendant, the mens rea, the thought behind the communication matters. That's even with an extremely conservative Supreme Court. That's with respect to threats. I feel it's a good likelihood that ultimately that will come to be also the jurisprudence of the Supreme Court with respect to quote unquote obscenity. And that's why I feel that the statute, if it becomes a statute, will be weaker without those paragraphs. However, because I think the aim of the policy itself is important enough, I'm going to vote in favor of passage.
Thank you for sharing your thoughts, Representative. Anybody else wish to be recognized? Is the committee ready for a vote? It appears that we are.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan.
Yes.
Senator Hagan votes yes. Representative Poirier. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Representative Poirier. Representative Poirier is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 11 members voting in the affirmative, 0 in the negative, 3 members are absent. That is the vote of the committee.
Thank you. And so the vote is 11 in favor, 0 against, and 3 absent. And with that, we have concluded our work. Thank you to everyone who stayed here late tonight with us to resolve this legislation. And Janet, do you need anything else from us on this bill? Okay, so we'll close the work session on LD 524. And is there anything that committee members wish to share? Yes, Representative Sato. No.
Make a motion, we. Okay.
That's a good idea. Okay, we've got a motion to adjourn. Is there a second?